and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
May I have roll call, please? Way over there.
Sir? Here. Mr. Hara?
Here.
Mr. Kucera?
Here.
Mr. Nushai?
Here.
Ms. Redmond?
Here.
Mr. Sanaki?
Here.
Mr. Solomon?
Here.
Mr. Tinlin? Mr. Watson?
We have quorum. Thank you very much. Agenda item number 4 is approval of this agenda. Does anyone have anything that they'd like to add, subtract, or change on this agenda? Seeing none, we will just approve it. And we'll move on to the approval of the regular meeting minutes from November 22, 2022.
Mr. Chair, I make a motion that we approve the regular minutes from November 22nd, 2022 as published.
Mr. Chair, if I may, there were just a few amendments I wanted
Would you
to.
make support first, and then we can open up
Oh, okay.
debate? Okay, you'll support. And then what are your questions before we
What do I have to do? Do I have to say I support?
just say support?
Okay.
Now I have a motion and support. Now we can
I see.
discuss it
Sorry,
before we go
support,
to the
yes,
vote.
support.
So your questions would be?
Well, just on the minutes, I think we discussed on agenda item number 8 regarding the master plan. I appreciate Nick's inclusion of the topics of the master plan. I would have liked to have seen some wording specific to the infrastructure request, that the master plan review start including emphasis on the infrastructure. So it was a comment, it wasn't a specific commitment by anybody to agree on language, but just that was a priority for the master plan review, was infrastructure, which has been absent from it up to this point. And then I believe we also had discussed temporary occupancy permits and how we can get that back to the planning commission for approval. I didn't see that in the minutes. I don't know if that's a big deal or not, but would have liked to have seen it in there if possible. That's all.
Okay. Aside from that.
Do we want to add a bullet point with respect to your first topic, and I lost it?
Just wanted to have the phrase that we were,
Infrastructure.
yeah,
Yeah.
requesting infrastructure consideration in the master plan review.
I think that makes sense.
So you want to amend the minutes to add that?
I think we could amend the minutes to add as a bullet point in the topics that were discussed, because we did spend a considerable amount of time on it.
Okay.
So that would be just a statement about the, I believe it's, if we're paraphrasing it, it was the significance of discussion of our infrastructure as we discuss the continuation of the master plan.
So you can amend your motion to do that. And then will you still support that motion?
I hope so, yes.
Okay?
I can propose it.
If everybody.
Yes.
Okay. So if everybody's in agreement on it, I'll take a roll call vote on it, please.
Mr. Kucera?
Yes.
Mr. Nushai?
Yes.
Ms. Redmond?
Yes.
Mr. Sanaki?
Yes.
Mr. Solomon?
Yes.
Mr. Fitzer?
Yes.
Mr. Hara?
Yes.
Motion carries.
Thank you.
Thank you.
Agenda item number 6 is public discussion, items not on the agenda. Is there anyone here from the public wishing to discuss anything? Seeing none, I will then close public discussion, and we'll open up agenda item number 7, which is a public hearing on the zoning ordinance amendments related to sign ordinance, sections 4.7 and 4.52, advisory hearing on amended sign ordinance. I believe Mr. Tangeri will walk us through this, right?
Sure. Thanks. So on your agenda, you see public hearing on 4.7 and 4.52, and then advisory hearing on sign ordinance, and that's just a matter of how state law is written. Your sign ordinance isn't part of your zoning ordinance, so that's only adopted by the city council, and you're not required to hold a public hearing on it. But we've been working on the sign ordinance. We want, if anybody has comments, to hear them. And we have 2 small zoning ordinance amendments that go along with that. So we're having a public hearing for those, and we're going to roll any comments anyone might have on the sign ordinance into that hearing, because they're all related. They all go together, and it just makes sense to do it that way. And I think even if we didn't have these 2 zoning items, we would have held a hearing on the sign ordinance. It's just a nice thing to do for anybody who might be following along. So as a reminder, and we've discussed this at a lot of meetings here, and we arrived at all this language over time and through a process. But there were some standards related to drive-through uses in the sign ordinance that are being integrated into the zoning ordinance. There were some standards related to gas stations, particularly around the pumps, that are being integrated into the zoning ordinance. And then in the sign ordinance itself has been reorganized, restructured, and for the most part, the size of signs didn't change. The general regulations that govern what signs look like didn't change very much. We did build in a little more flexibility, though. So, whereas before we had this hard and fast one sign on a wall thing, now you're able to more easily split up the total permissible area into multiple signs, which is something that we know a lot of businesses do. So we're trying to respond to a lot of what we've seen come to the Zoning Board of Appeals and make that a simpler thing for people to do. Because sometimes just one sign doesn't make the most sense for a business. Sometimes a principal sign and a smaller secondary sign is what they want to have on their wall, and they want it for a reason. So we're making that essentially easier to do by right. Whereas before it was really a process where if somebody wanted, like let's say it was a pharmacy or something, which almost always has more than one sign on its wall, they were all going to the Zoning Board of Appeals and asking, can we split up our permissible area into multiple signs? So we're hoping that helps there. Otherwise, we really tried to clarify as much as we could the regulations that were there, really be clear about how we measure things, really be clear about how things are lighted, be clear about what our maintenance standards are. The last sign ordinance had a deadline for removal of non-conforming signs that came and went, and non-conforming signs were never removed. This time, we didn't put any kind of sunset date in there. We just are going to be doing it over time as signs are altered. Non-conforming signs will be brought into compliance.
And can we bring them down when the establishment changes hands, or what control do we have over that?
It's really more when you're going to work on the sign. If you're doing something with signs on your property, then you're bringing things into compliance at that point. So it wouldn't necessarily be a change of ownership, but if you're putting up a new sign because you're the new proprietor,
Okay, so
then
it's not necessarily hinged on a site plan or anything like that, but if they change
Right.
signage.
exactly, if they change signage.
Okay,
Yeah.
that makes sense, yeah.
Yeah. So, I mean, that's a little summary. If anybody's got any questions or wants to make any comments, I think now would be the time, and then we can open the hearing.
I actually can piggyback off of that a little bit, I guess. I guess this, within the definitions, the vacant sign definition, okay, hold on, maybe it's not vacant, that's just my notes. All right, abandoned signs. How would that correlate to like vacant buildings? And would that be let's say a building is vacated and it's been there for a certain amount of time, would that trigger building department to go and ask that building to, remove a sign? Or is...
As a matter of practice, I don't know that it would be done that way. When the building, obviously, if there was a safety hazard or a blight issue, yeah, then definitely. But if you've got a building that's unoccupied and its sign is still there, maybe Joan or Nick could speak to that, but do you think we would actively enforce on that? Most likely, we would probably not.
According to the definition, the actual premises of that is no longer in use. I guess when you break things down to maintained properly, that's, very subjective. But if a building has been there for years and that building no longer is a use for so long, would that be a reason to ask them to remove a sign that is no longer conforming?
We could do that, yes. Again, I think just from how that actually works in the real world, it's a matter of policy and actual enforcement resources. But based on what we have here, yes, we can do that. It's just historically, it's never been done that way.
So if, and I don't want to go off on too many different ways here, but if we decided that we wanted to discuss further, vacant buildings that have been vacant for 6 months or longer, would that be an enforcement mechanism that we can build into potentially going about that?
We could become more explicit about that sort of enforcement. Again, if it really all comes down to enforcement resources and policy. We're trying not to force, generally with enforcement language, you try not to force the city into that kind of proactive enforcement if we're not positive that we're going to be able to follow through on it, I guess. And the last sign ordinance, one of its primary flaws was that it was trying to do that proactive thing where it was like, no, we're getting rid of all these non-conforming signs. And then it never happened. And I don't want that. I don't want that to ride into the future, I guess, is what I'm saying,
So was that, I guess I didn't go back and watch those meetings, but was that like kind of the premise of those non-conforming signs in order to help move vacant buildings along, or was that outside of
Well,
that?
the idea behind the old non-conforming sign regulations, the current non-conforming sign regulations say anytime you touch your signs, if you've got non-conforming signs, they have to come into compliance.
Mm-hmm.
The old ones said by this date, all non-conforming signs have to be removed. And that never happened because it would have required an enforcement hammer to make it happen.
That went in front of city council, and at the time, we decided it was too costly for the businesses
Exactly.
to take their signs down. So we canceled the deadline on it.
So I know we've discussed, and again, maybe this is a topic for when we talk master plan, but in terms of addressing vacant buildings and our ability to kind of take lead on those vacant buildings and hold owners to a certain level of accountability, I don't know what our ability is there legally, but we've talked about like, if there's a bunch of vacant land that we might require a certain green space to be applied there, it would seem like this would kind of be within the realm of imposing certain standards that we hold to a vacant in order to kind of, incentivize an actual occupant to take over that site.
Right. Well, when an occupant takes over the site, The sign, if it's been more than 90 days since the last business left, the sign's lost its non-conforming status at that point. So when a new occupant comes into the site, they're going to have to do something with it. Rennis, correct me if I'm wrong, we have a vacant buildings ordinance now, don't we? Yes. I'm not too familiar with the vacant building ordinance. It's kind of outside my purview. But we do actually have a vacant building ordinance in the city.
So, so your premise would state, you would assume that someone's actually coming to that vacant building and it's actually priced at a price that people might occupy it. But I'm speaking from the other side of like incentivizing that open vacant building sitting there and, whatever it's being used for on that owner's part, they might feel more incentive to actually, adjust price to the market versus leaving it vacant. I guess I will have to look up our vacant building and our ordinance addressing that and see if that, signs are addressed in that. Is that something that would be addressed within the,
I don't think signs are addressed in the vacant building ordinance now.
okay. Well, I'm just wondering if that's something that we can kind of discuss further.
Yeah, I think we can discuss it further. I mean, for right now, I mean, obviously we got what we got, but we can discuss it in the future.
Yeah,
if you
I just
want.
saw it as a definition and it piqued my interest.
Kind of along those lines, that did remind me on page 15, under 36-7(1)(e), it says 90 days following the cessation of any business or related activity, a non-conforming sign shall lose its legal status and shall be removed and or brought into compliance. And then
Right.
non-compliance within 30 days after notice shall authorize the building official to initiate removal of the sign structure. And it goes on. But
Right. Yeah, I mean, that is essentially what was being discussed here. But like I said, it becomes a matter of enforcement. We don't always necessarily know when a building moves out. It's a little more complicated than the ordinance language implies that it is.
Well, I don't want to call a specific building out, but there's been buildings that have been proposed with a site plan in front of us that we know for certain have been vacant for years.
Sure.
With non-conforming signs in front of them. What is it, the legal risk versus reward that might keep us from pursuing something like enforcement or, Joe, I'm sorry, I don't.
Yeah, I mean,
I hate to
you're
put this
asking
on
someone
you.
whose gig isn't enforcement.
I
so it's
get
like,
I get that, but these are, I guess I'm asking them out loud versus
Sure.
expecting an answer from you. But like, so what's keeping us from actually, following through on, thank you for that. From these, we've got it, spelled out a couple different ways here. A way to trigger enforcement is a lack of resources or a actual like legal thing that we go about in assessing. That would be helpful to know because
Sure.
a lot of feedback that at least I see and I've heard is the vacant buildings that I think we could easily very, very well, address,
Sure.
not just within signs, but within the master plan as well.
Sure.
If nobody else has other questions, temporary signs, are we intending to put a timeline on what defines a temporary sign or?
Well, we do, actually. We have a timeline in there.
Oh,
Here's
I
the-
missed that.
Here's the thing with temporary signs, particularly if they're, there's a First Amendment element to that. And if so, there's no one walking around the community with a clicker saying like, okay, this sign went in that day, this sign went in that day, this sign went in that day, this sign went in that day. Everybody gets a certain amount of right to free speech on their property. And if you put out in this home, we believe sign and it stays there for a year, unless it's falling apart and someone is complaining about it, or it's like visibly tattered when one of our people drives by it, we're not going to say, oh, that's been there for more than 60 days, you have to take it out. Because you've always got an allowance for something to be out there, and you could take it out for a day and put it right back. You know, so functionally, on a residential property, that time limit is probably not going to be something that's actively enforced. However, for like a business that's putting out a sign for its sale or something, that's something that will be watched a little more closely.
Yeah.
And people who come in for, if they need a permit because it's a large enough sign, they're going to be told this is the term that you can have that sign up. So we have some enforceability there, but as a practical matter, and from a, like, you know, not stepping on the First Amendment standpoint, on residential properties, generally speaking, so long as signs are not creating some sort of nuisance or becoming tattered or blighted, we're not generally going to be enforcing any kind of 60-day time period.
So I was thinking of it, I guess not in terms of like on your personal property and I didn't notice so much that we specify the difference between like the actual resident property versus like the city property. You know, I know some cities get very specific. Like if I go to Birmingham and put up an open house sign, it'll be gone and I'll never get it back, right?
Right.
But I think our city's very great. I'm sure it's DPW that goes around, and if there's garage sale signs that are like hanging out a week
Sure.
later, they just clean them up.
Yep.
Lost cat kind of things, you know, but there's, you know, specifically like lost cat signs that kind of hit every single sign
Sure,
for months
sure.
on end. I guess it's not a big issue, but I was just curious about that component of like, hey, if you're not coming out here to take down your garage sale sign, you should probably do it within so much time, even after an event, right?
Yeah, strictly speaking, people aren't supposed to be putting signs in the right of way or on telephone poles or anything like that. There's a certain amount of, I guess, understanding and tolerance of someone's having a garage sale. They put their sign out on a Saturday. Okay, if it's still there a week later, yeah, take it and throw it away. And also, you know, our people don't work on the weekend, so if there's a sign that's out there on a Saturday or a Sunday, it's not going to get, you know, noticed on a Saturday or a Sunday by any city personnel. But yeah, I mean, strictly speaking, people aren't supposed to be putting signs in the right of way or on telephone poles or trees for that matter. And those can be removed by city personnel if they're in those locations. And there doesn't really have to be any, you know, time frame observed or anything. They can just be removed.
Yeah, that seems to be an enforcement problem. Under temporary signs here, we have ordinances like H. The sign must be stored inside when not displayed and shall not be displayed outside of operating hours of the establishment placing the sign. These are an A-frame sign.
No, the A-frame
We've
signs.
got quite a
yeah.
few A-frames around town, and they don't always bring them in at night. I think they should.
Right, and I don't think we actually have that in the ordinance right now. That's a new provision, so.
And J, the sign shall not contain moving parts or have balloons, windsocks, pinwheels, streamers, pendants, or similar adornment. You see quite a few of those windsock things, and some of them are getting off of their property and moving on to the right-of-way property. I've seen it around town.
Sure.
But that's an enforcement problem. That should be dealt with through them.
Yeah, once this is adopted, we'll take that under advisement, because that's another thing that's not actually in the ordinance right now. Actually, while we're on the subject of the balloons, windsocks, et cetera, on those A-frame signs, there's a reason that those are prohibited, and that's that the balloon starts blowing across the sidewalk if there's a visually impaired person walking by. Suddenly they're being attacked
get
by
beat
a
up by a
balloon that they
balloon.
did not know was there. You know, it's a safety issue. So, yeah, there's a reason that that's in there, and has to do with people's safety and unimpeded travel on the sidewalk.
Mr. Chair, if I may.
Any other questions? Go ahead.
Yeah, one omission I may have missed, but I thought there was language in the previous sign ordinance that prevented like apothecary-style signs and, big pluses and things like this for pharmaceuticals, shall we say.
There's a difference between signage and symbols. I
Yeah,
think.
there wasn't that I recall, and for the use that I think you're referring to,
Yeah.
that's actually regulated separately.
Oh,
Because, well, first of all, we don't permit any of those businesses, but second, you can, under state law, when you regulate those businesses, you can prohibit that kind of iconography
But it
and other signage.
but should not that be in the sign ordinance?
Well, typically, it's actually done in whatever ordinance you're regulating those businesses in. That's how it's done in most communities in Michigan anyway. And at the moment, we're not permitting those businesses, but
It
if
just
we
so
ever
happens
were
at the
to-
moment that we're not doing that, so it's
Yeah.
kind of redundant in a way. But as we are reviewing this, and I think a lot of these are very good changes, and to the other commissioners, I think enforcement is well covered, and I think we distinguish aging signs from a live business well, like we had the Fabric Care awning that was sort of tethered for a while. That wasn't an abandoned business, but it was a out of maintenance thing. And I think the language I read here is we could have cited that, and there's language to say, we can fine you $500. We could ask for support to get that remedied, and if you didn't, there's even language for the city to take that on. So I think that's good for dilapidated signs. I think you did a great job with that language, and abandoned signs as well. I think, unfortunately, Pumachug might be the next test for that, if that business isn't readily restored. But even that, I think, also is covered in your ordinance. So for me, the only thing that I would like to maybe have seen considered to be included under section 3 for prohibited signs would be, structures or displays that convey, pictures, symbols, emblems, logos that include those things that pertain to the cannabis business, perhaps. So just because we don't allow it, and at this moment, that would be congruent with the rest of our ordinances.
You get into a tricky game there. Mr. Sanaki mentioned before with our problem with Taco Bell. That's the company name, Taco Bell, but their logo is a Taco Bell. So is it a logo? Is it a symbol? Is it considered signage?
Right. And that's part of the reason that I think it belongs in a cannabis-related business ordinance, because the state law is very specific about what you can prohibit. And I think what you'd want to do in that ordinance, if you were ever to permit those uses, is you'd want to take that language right out of the statute and say, here's what's prohibited. In that ordinance, you could always reference it in the sign ordinance at that time, of course.
Yeah, there are other things in here like human genitalia and nude human bodies and absurd or obscene words and gestures. So, for whatever reasons, the authors of this included that detail.
Well, can I, do you mind if I jump?
I'm finished.
I believe maybe things have changed, but since I looked at the state last time regulation, you are allowed to exclude certain signage in terms of cannabis.
Right, exactly.
Right, in certain symbols and even colors, I believe. And it might be beneficial, actually, now that I'm thinking about it, because there is a component of cannabis that might be CBD related that could be advertised that might not necessarily require a, city. I don't see anything in the city right now, but I'm just thinking of a
Well,
possibility.
CBD is not cannabis, though, and that's not covered under the cannabis law, as far as I'm aware.
CBD is not?
No. it's
Oh,
not.
okay.
Yeah.
Oh, okay.
Yeah, so if you put up a window sign saying CBD
CBD
oil or
with a
something, that's not
leaf.
something that we can say you can't do. Yeah.
Right. The leaf symbol only applies if you're selling cannabis.
Yeah, exactly.
Okay.
Yeah.
And that's in the state.
It's in this. The I'm going to forget the name of the law now, even though I've read it like 7,000 times. Yeah, the MRMA. Yes.
It's changed about
There's like
7,000 times.
4 of them.
Yeah.
So
3 M's. and a couple
yeah,
other
but it's
vowels.
in the MRTMA,
Yeah.
whatever that stands for. That's the law that says you can prohibit the sign.
And that specifies that you can't specifically call out cannabis, that it has to be, or, okay, I'm sorry, not cannabis, THC.
Yeah,
Because
THC.
THC is technically, I think, a component of, right?
THC is the
Or wait, no, I'm talking the other one.
intoxicating
I'm talking the other one.
component of the drug, yeah.
Wait. I'm gonna throw, all right, I don't want to go there. I don't know what symbol it is. But the one that's not,
Yeah, THC is the intoxicating component of the
I'm
drug,
talking about the
yeah.
other one. CBD.
CBD.
Yes.
CBD
So
is not
in that
addressed, yeah.
MRA, it doesn't, it says that you can't use that for that.
CBD
Okay.
is otherwise legal outside of the scope of that law, so
Okay.
it's not addressed there.
Okay.
So it is entirely possible, though, that we could have ordinances that lean back to the sign ordinances, right? That in general, whether it's a CBD or THC business, or it's a concrete business, or it's a restaurant business, in general, those ordinances are congruent and support the signed ordinances that we have in this document. So in general, I think that it's not inappropriate for the sign ordinance to have the detail for those types of signs, the leaves and the pluses and whatever. I would have liked to have seen it in there as a prohibited sign for the moment, with the understanding if that law changes and Clausen goes full THC and we want all of those dispensaries in here, then the sign ordinance has to change to accommodate that, progression. But for the moment, if it was in here, I think it would support our existing ordinance structure.
I'm gonna defer to our attorney on that,
Sure.
because I mean I know exactly where it would go if we add it. It's very easy to add.
Prohibited sign, right?
So,
Yeah, you could, but I think I agree with Joe, given the fact that we are not allowing such businesses. It is better to keep it under that business. And of course, the answer to your earlier question is, of course, they work in congruence together.
So, sorry?
Of course, they work in congruence together.
Okay.
Of course, they will piggyback on one another. Of course, there's always connection between these ordinances. It goes without saying. But I think properly, to legislate properly, since we're not allowing any such uses in any district in the city, as far as marijuana is concerned, I would almost think it would be opening some door, even though we're not really opening a door, you're just denying a specific kind of sign, but you'd be granting sort of an opening that we don't want to do right now. At the time,
How? It would be under the
It's like, we
prohibited,
don't want you here, but here's the restrictions on the signs.
Correct.
You can have.
yeah.
It's
It's almost a double door lock.
Yeah.
I beg to differ. So, but regardless, we don't have to consider it for purposes of this at this particular point in time. If Clausen were to ever go that direction, which I think Clausen has spoken in that regard, through a referendum, then we would address it there, and if needed, you could always amend this ordinance
Yeah.
to allow it.
But here's how I look at it. That, as you said, Clausen has spoken, and not everyone in Clausen agreed to that, by the way, but for the moment, that is how Clausen has spoken. And I feel like, is it not the case that we have a duty to make our sign ordinances and our child ordinances for these types of referendums support that direction? And not leave it loosey-goosey. There is so many pages on this ordinance that are very detailed to talk about illumination and mounting and shapes and sizes and logos and the morality of things, nude bodies and whatnot, And as you say, there's very specific laws that prohibit people from, having prostitution in downtown Clausen. But we chose in the sign ordinance to specifically say you cannot even begin to deface our city with that kind of nasty-looking signs because it's in our sign ordinance. So it won't even get to second base because it's prohibited by the sign ordinance. So if I understand you correctly, it's very unnecessary to do this. I don't understand why it is putting up a plant your weed business here. I don't understand why it opens a door. I see it as a provision to protect against such a thing at the current situation. I see it as a glaring omission for what is the purpose of this ordinance, is to control what kind of signs go up and what kind of signs don't. So, but I want to make sure I understand correctly that if we put it here, it's not an interference with our current ordinances. That is a fair statement, right? To prevent marijuana dispensaries in downtown?
To allow them altogether.
Correct.
Can I add in? If, it might be that if we add that provision in here, we're unlawfully excluding things such as CBD from having such sign.
The
With-
CBD sign would be okay.
Well, what if they put leaves on the CBD sign? That would be okay?
I would hope not.
So then how would you actually write that within this? Here, like, how would you put that in the offensive category of like nudes? You know, like, I don't know. Well, you referenced that as, so I'm wondering, to be able to put that here and say it's okay for this, but not okay for this, might be more complex than where you're
I
going
mean,
with that.
I guess what it comes down to for me is that I want to make sure that we're doing everything under the right statutory authority.
I agree.
So there's a law that permits communities to allow cannabis businesses, and that's the MRTMA. And the MRTMA also then says a community may prohibit that business from having such signs. And that's my basis for thinking that that's the place where you do that prohibition. And putting it in the sign ordinance, I don't know that it does any harm, but I also don't think it's necessary. I guess that's just my position on it, because, you know, if we were to adopt an ordinance as authorized by the MRTMA, then we'd be acting on that statutory authority within that ordinance to prohibit those signs. Do you see what I'm saying?
I mean, I think if prostitution became legal, we would have to change the sign ordinance maybe, because there's things in here that very
When
clearly.
it does, we will change the ordinance at that point in time.
Right, exactly.
I think we're all agreeing on that one.
Yeah.
I think that's a point that's universally agreed.
Right.
We don't have anything in our books that says no crack signs, no 8-ball pictures on our window signs. But we know that that's never going to appear on a window in Clawson. And if and when it does, Barb Chambers is going to go out there with all her might and fury and address the topic, with or without ordinance, because it'll affect other options. But again, it's not a business that is legal, it's not permitted in this city. I think as a concern, it's probably a valid concern, but it's something that we address appropriately down the road if there's ever any change.
No
Renus, I don't
disrespect to
think
you or
that's
to
on.
Mrs. Chambers, but I think it belongs in the ordinance. I'd like it to be very crystal clear in the ordinance, and that, I think, makes Barb's job a lot easier and whoever is in her place, so.
And there's an easy way to do so that you don't, because, I think we just mentioned this earlier in conversation, sometimes you can debate until you reach the age of Methuselah without getting anywhere. There's a simple way to get there. You just make a motion for an amendment. If there's a second, you vote, and that's it. The body speaks by way of the vote. I think that's the proper way to do it. If you want it there, you could have it there.
Yeah, there would be two ways you could do that. One is you could have an independent motion to, and I'm opening statute because I want to make sure that it's got the right.
Page 12 in the packet, section
No,
F.
I'm actually opening the MRTMA.
Oh, okay,
I have it
okay,
on my
okay,
computer.
yeah.
I keep
Can
it
we
there.
pause for a second and go
Sure.
back to the agenda? And the agenda said that this was the public hearing on items that we had discussed a whole lot.
Yep.
So it's not written in the agenda, but I'm anticipating that at some point in time, we will open and close the public hearing because that's our requirement.
That's true. Yeah.
And then we would have a recommendation based upon the public hearing as to whether or not to send this particular language to council for their review and recommendation for approval. With that we aren't proposing in this discussion at this time to take anything out of the publication. Maybe we'd have just ought to propose to put those items on for further discussion and review, because it would be an ad and it would just be somewhere, however it is in the particular ordinance, to create another paragraph, another bullet point, whatever it is, for those particular things, because this is like the 5th or 6th meeting where we talked about signs to get to this point, and that was our process, but we got to this point. This was the public hearing. Is that where we go on the agenda after the public hearing? It's not stated that we make a motion, or are we just having the
you-
public hearing and then?
You go to the public hearing and then it's the planning commission has a motion at its pleasure. You do not necessarily have to act on the same night you have a public hearing, but it's typical with an amendment because you've worked on the amendment to that point and you're comfortable with it to the point where you've set a public hearing on it. But it's not a requirement that you actually have a motion the same night as a public hearing. You
if we-
could postpone or if you chose to.
If we adjusted this, we adapted, added something to it, would that cause us to have another public hearing on it?
It would not.
It would not, okay.
What the MRTMA says is that a municipality may adopt other ordinances that are not unreasonably impractical and do not conflict with this act or any rule promulgated subject pursuant to this act, and that A, establish reasonable restrictions on public signs related to marijuana establishments. So that's what the statute says. It doesn't actually get into like what the symbology is. Yeah, there's nothing else about signs in here, so that's it.
Truthfully, you introduced me to this, Joe, like a year ago. You had actually, my memory was you said that the green plus or cross and so
Yeah.
forth was specifically excluded, and I didn't know that until you had said that, so that stuck with me all that time. So I was
Yeah.
just looking for it in this version and didn't see it, so I was just wondering. So to the spirit of your comment, Commissioner, we should close public comment and.
Well, we got to open it
I haven't
first.
opened it yet.
Okay.
You opened it, I believe.
No.
Did he
No,
not?
the public hearing
I have
hasn't been
not.
opened
Oh.
yet.
No, we're still
Yeah,
having just open
so-
discussion on this.
All right.
I would say if there's no other discussion for the moment, let's park that.
Yeah.
Open the public hearing, have the public hearing, close the public hearing, and then figure out what we're going to do.
Good idea. This is, agenda item is now open for public hearing. Is there anyone from the public wishing to discuss this matter? Seeing none, I will close public hearing. Now we're back on discussion level.
Okay.
Yeah, can I just make a comment?
Sure.
To your point, I'm just trying to follow. So under prohibited signs, number 3, section F, the way that I'm interpreting, what's kind of listed here, it all tends to be obscene words and gestures. And my perspective is I don't necessarily put a cannabis leaf under that category. It may be a different perspective, a more liberal, younger perspective. I don't know, is that where you want to put it? I don't kind of equate it with
I
human
wouldn't
genitalia
think
or.
it would go under F. No, it'd be
Yeah.
its own like
Okay, I just want to clarify, because that seems like,
Yeah.
I thought that's a
it'd be
section we're
I
referring to.
agree
K
with
or
you,
something.
you know, I think it's different, yeah.
Right. Okay, I just wanted to clarify where,
Yeah. I think
you'll
it'd be
make a motion, I
K.
assume, if you want to place it somewhere. I don't believe it would fit in that section.
Right.
Are you so inclined to make a motion to that effect?
Well, yes, but I would tell you that I was under the impression that we were trying to get something on the council's desk, right? This has been, as you said,
Yeah.
Commissioner, it's been discussed so many times, and a lot of good amendments were made, and I think the language has improved. We've got clarity on the grandfather clause for old signs. We've done what we can to protect ZBA from hassle and conflicts there. So I like it. I think it's very well done. I would like to make a motion to add that, you know, cannabis leaves and dispensary-type symbols, which are not congruent with our current business laws, would be added as a separate section to this ordinance, and I would appreciate that opportunity to vote on that. And if it does, in fact, occur, either way, in fact, I personally think we should actually, I'm sorry to say, but have public comment again, because I think the community wasn't expecting that alteration specifically, and I would like to have the opportunity for the community to say something to that if that was specifically added to it.
If it was added, it would be added on the record here, and then it will
Right.
go to council where they'll have two hearings, so.
Okay, so they'll have
I
that
don't-
opportunity?
Yeah, they'll have that opportunity.
So
yeah.
that is your motion that you want to add? You're going to need support for that. Someone support the motion?
Red hot issue. Incongruence with our existing ordinances.
I see no support, therefore the motion passes. It dies.
Guys,
Okay.
Anybody else want to add some changes or?
We can always address it again in the future, so.
sure.
Yeah, I can always come back.
Okay, so from there, one necessary motion, one optional motion. The necessary motion is to move amendments to sections 4.7 and 4.52 onto council. The optional motion, which I assume you'll take advantage of, is to advise city council that you recommend the adoption of the amended sign ordinance. And it's an advisory motion because of the way state law is structured with respect to general ordinances versus zoning ordinances. But I think for our purposes, it makes sense for city council to understand that, yes, we are indeed recommending this new sign language to them for their adoption.
I fail to see the difference in the two motions. We're sending it on to council either way, but you're sending it with our blessing or without? Is that?
Yeah, I mean, that's essentially, it either lands on their desk with no motion from the planning commission saying one way or another, or it lands on their desk with the planning
No.
commission saying, we've worked on developing this ordinance and we recommend you adopt it.
Okay.
So I think it's good for them to understand the work you've put into it and that you're actually recommending its adoption.
I would entertain a motion to that effect, seeing as I don't think Joe can make the motion.
I'll make a
That's true.
motion that we send the zoning ordinance amendments to the sign ordinance, sections 4.7 and 4.52, to the city council for recommendation.
For approval. Who's that?
I have a motion, support, any additions, subtractions? May I have roll call, please?
Aki,
Yes.
Mr. Solomon,
Yes.
Mr. Fitzer,
Yes.
Mr. Harrow,
No.
Mr. Cusero,
Yes.
Mr. Nushai. Mrs. Redmond.
Yes.
Thank you.
Motion passes. Thank you. Agenda item number 8 is another public hearing. It's a public hearing on the zoning ordinance amendment, section 5.1, regarding accessory building appearance. This is going to be interesting.
Okay, just give me 1 second here, making some notes for myself. All right, and now I gotta get to that page. So this is just adding one little paragraph to section 512. The exterior finished materials and colors of any accessory building other than a shed, as defined in this ordinance, shall match or complement the principal building. Where a determination of compatibility cannot be reached by the building department, the application may be referred to the planning commission for a final determination. That's what we're adding to the accessory building regulations.
Do you feel that's defined enough to be able to support?
Yes, I think that gives the department something to work with.
Was that recommended by the building department in order
Yeah, the
to-
building department's fine with the language, so.
It's a good starting point, but I can see a lot of residents coming in and complaining about, and we're having debates over colors and windows and,
So what would be the
Materials.
planning commission's, would it be essentially like a site plan that we would be either approving or disproving? It's
Yeah.
different than the ZBA, right?
Yeah, right, exactly. It's you're making a final determination of compatibility, essentially. So, you're the body that, is the keeper of the master plan. You're the keeper of the zoning ordinance. You are kind of the arbiter of, does it meet the spirit and intent of the master plan and the zoning ordinance?
Okay, well, I like that, but to me, that, and maybe I'm reading too far into it, but it might say that we need more mechanisms to weigh the actual written language versus the product, right? Like, what are we weighing this language against? Just purely color? I mean, red is red, but red is also lots of different variations of red. So, and I don't want to get too detailed or lost in it, but like, was the building department having an issue with the implementation because there's too much discussion on like, well, I think that's gray and that's gray too, so it's great, or?
It was more, it had partly to do with large expanses of blank wall and things that they were looking at, and just having some trouble figuring out, what actually fit in the neighborhood. But they didn't really have any language to look at in the ordinance to say, there was nothing in there that said anything about it really, so we're just giving them something to work with. And, match or complement is intentional. We're not saying that if you've got a brick house, you have to have a brick garage, It's, we're
kills
trying
the
to be
pole barn.
practical here. And it's really, ultimately, if the planning commission ever sees one of these, I'd be surprised. It's not usually that difficult for the building department to make some sort of determination on something like this. We're just trying to give them something to point to in the ordinance when someone comes in with something that's just outlandishly out of character, basically, and say, look, we have a compatibility standard here. Can you go in a somewhat different direction with this building and its appearance, so that we don't get corrugated metal that's like the color of galvanized steel building next to a house with traditional siding or something like that.
So as long as that corrugated metals match the color of the house, then that would be more conforming, right?
It says
would make
materials and colored.
Yeah,
Oh, materials and color.
Exactly. It would
But-
make it more conforming, but
So, okay, there's a lot of looseness to this, right?
Yeah,
Because you
exactly.
said we're not going to require
'cause
brick, and I respect that.
Unless you're going to be architecturally prescriptive, it sort of has to be a little bit loose.
So but it's just kind of, there's,
and they're already facing other restrictions on the size of the building, the location on their lot.
Right,
If
exactly.
they
Yeah.
have to do
Height and all that.
permeability
but
of
without an
property,
enforcement mechanism, just like we
So,
saw with the
appearance is
signs.
the only problem, really. It's the only debatable thing. I feel it's a little loose myself, because we're gonna end up with people coming in, discussing it with the building department, and they're gonna come to us, like the ZBA was getting a lot of things. Anytime you say something should be compatible with this, it opens up a free-for-all of opinions on it. So it's a little loose, but I think if that makes the building department happy, and if they can deal with that, I can deal with that also.
And Joe, was there anything that you saw in any kind of surrounding cities that have something like this. I mean, to the same point,
it's-
there's a little vagueness to it.
Yeah.
I get why they're asking for it. I don't know how you make final decisions.
It's
You
a
know.
pretty common type of standard. Yeah, you see this kind of language in lots and lots of ordinances. In fact, pretty dead on. Like we define a shed, so we have a shed that's not a shed is defined in this ordinance because
Right.
Someone's going to Home Depot and they're buying a shed and they're putting it next to their garage. We're not going to make them worry about the color and finish materials on a 100 square foot shed, but that's something that was added here. But I mean, there's language like this, a paragraph like this, and I mean, I don't know how many ordinances have this in them. It's something there for the building department to lean on when someone comes in with something that just clearly doesn't fit. And now we have a way to say, look, this doesn't fit. And again, if you want to get much more detailed than that, it starts to become architecturally prescriptive, and it also starts to add a lot of cost to whatever the person is trying to do.
And luckily, not everybody wants a pole barn in their backyard, so it's a
Right.
limited market we're playing
Yeah.
to.
Right.
Right.
Yeah.
I like that, obviously shed is excluded. That makes sense.
Any more discussion from the,
Well, just one thing.
Sure.
It is loose. It is very, very loose language. And if I read it correctly, where a determination of compatibility cannot be reached by the building department, the application could be referred to the planning commission for a final determination. So I'm trying to understand whether that is what is the definition of a determination? Is that
It
approval?
would be they either approve it or deny it, yeah.
Right, so if it comes to the building department, and it's complimentary enough, you'll approve it.
Right.
If it's in your judgment,
if it's problematic, let's ship it over to us, back to us, yeah.
right. But if they,
They have the power to deny it as well.
They do have the power to deny
Okay.
it, yeah.
So
If it's just
I can't
very
see
clear.
many situations where they want our input over their own, which is
Right.
why, okay, sorry.
And somebody's pretty persistent that they want a pastel or a lime green pole barn.
Right, exactly. It's
Yeah.
it's an out if they say, look, we don't feel that this is compatible. It gives an out so that there can be a determination made in public by a wider group of people.
Is
So
there an
there's-
appeal process for that? I'm just curious.
Yeah, ultimately the appeal would go to a zoning board of appeals. Yeah.
Yeah.
Oh, okay.
Yeah.
well, could that language maybe be put in here? Because
Right.
the way I read this is.
Well, that's a given though. That's because that's where everything goes. If someone disagrees with a decision of the planning commission or an official or something, it would go to the zoning board of appeals.
Well, then I would say it should say where approval of compatibility cannot be reached by the building department, then so on, as you say. What I'm concerned about here is like, we'll never see it. You'll just deny it to the guy and we'll never know.
Well, I think that we might have our finger on it. If, let's say, 100 people start coming in with pole barns, then we'll at least have a finger on the planning commission on what things we might need to consider. Is that kind of like why we're coming to the planning commission before the ZBA?
Yeah. Right,
Just so that we can keep our finger on the pulse, in essence, of like,
Right. If you're getting
what
a
might
lot
be
of
coming, and so we
issues.
can kind of pivot and potentially reform our ordinance to fit those needs if necessary?
Yeah, it would give you a kind of a front seat.
Okay.
I guess the rest of ordinances are very specific that I don't really lose sleep at night that any power is being misused because there's just such specific language on it. But this is so loose that it's up to you guys to make up your own minds whether it's complimentary or not.
Well,
And
I
if
mean,
it is, I'm going to see it.
I guess what I would say now is
Yeah,
it's a lot tighter than nothing.
Yes.
that's fair.
Well, I think it's congruent with a new trend of what might be to come in terms of how we might want to reform ordinances so that we still have, as the planning commission, kind of like a know of what's to come and what we see happening, maybe. I don't know. Trying to look for the positive.
I'm just, as this thing is bound to evolve, I'm just trying to drive some of the discussion here and take it away from the building department, because I think they're not very well, their minds are probably not made up any more than ours are. So there's 3 cases, and they agree, it happens. I'll see it next door when I see it next door.
Yep.
B, it doesn't happen. Maybe you come in here and say, we rejected 10 applications for pole barns, but you don't have to. And so let's just say you don't. I never hear about it. The neighbors are upset, but I don't talk to them, so I don't care. And then the 3rd case is you're like, we don't know if this is compatible or not. We're punching it to planning. And I think that's what you're saying is
Right.
always going to happen. And I'm just saying, can we make the language a little bit more specific so that is driven to happen as we undoubtedly add specificity to that language that is rather vague right now?
So the second sentence might be better intended to say where the applicant and the building department don't come to a consensus decision, then the applicant has the option to address the planning commission to reach a consensus. Something in that direction,
Does that conflict with the current
Yeah, the
appeal
applicant
process?
would always have, because it's always applicant-driven, right? So the applicant would always have the opportunity, even given how it's, and actually, I agree in the sense that the language itself, because it uses the terminology that it uses, is may be referred. It talks about the specific instance where we have no agreement in place, we may refer to you. However, the applicant would always have that option to come to you.
Right.
It's just as a matter of course, and it's always applicant-driven. We wouldn't be, just much like any other aspect of your authority here is applicant-driven, right? We don't, it's not that we reach no consensus with respect to site plans between building and the applicant, and therefore it may be sent to you. Applicant brings it in, it comes to you.
But in that case, like, if the ordinance says you have the authority on this matter, and he comes in here on a random basis in other business and says, I'm really pissed that I didn't get my pole barn, what power do I have as a planning commissioner to say, well, look at this, I've got nothing here. It clearly was delegated to the building department to do. I don't know what any of us could do at that point.
And appropriately so. It starts at the building official. If there's agreement there, case over. If there's no agreement, it comes to you.
So I'm going to repeat what you said in ways I understand then. So they can always come here and complain. I just don't have any remedy for it, right?
I know, of course you do. If it comes on account of a complaint, you make a determination as a body,
To do what?
whether you agree that it is similar, close enough.
Compatible,
and
yeah.
compatible with the building or not.
Case by case?
Yes, sir.
I don't foresee that many of them coming about.
I don't either, yeah.
That's great news. It means the building officials are doing great at that particular instance. But
Right.
if not, then it comes to you and you make the determination on a case-by-case basis.
If someone comes into the building department and they say they're going to put up a pole barn, want to paint it bright purple, and they say no, do you think that they're going to come in front of us and say we want a bright purple building? You think they're going to try to bounce it off of 9 of us as opposed to the building department?
If they want to, that's exactly what they have.
And I
They have
think,
the option to
honestly,
do it. Yeah.
we're talking about that but I do think it's important that there at least is that appeal process. So, if somebody in the building department is just saying no to everything, there is the option for a resident to appeal to a different body. So I think that's fair language and.
Yeah, and I think you're exactly right, but that is on account of the structure of how the city operates, how our municipal authority operates, right? Which is the step that Joe was talking about. Planning commission, like building planning commission for zoning board of appeals, there's processes in place where it may go to the city. There's
Right.
nothing in this ordinance, for example, that says you have the right to file a lawsuit. But of course you do, right? It doesn't have to state there. Your authority doesn't come from this body or like Joe proposing that authority for someone to file a lawsuit. Of course you have the right
Yeah.
to borrow. So
Yeah,
that's
no,
the
I
point.
think this, I mean, it sounds like this came about because there were certain buildings that we didn't feel match the city. So we're giving language to say, this is why we're saying no to it. But as always, there's an appeal process for a
Right,
resident
exactly.
if they didn't feel that was fair. So generally, I think I'm okay with that language.
Okay, because this is a public hearing, I will now open this up to public hearing. Does anyone from the public wish to say anything? Seeing none, I will now close public hearing. And do we want to continue on with the discussion, or do we want to make a motion?
Are we making a motion potentially to recommend this, or because
Yeah,
this is our
it'd be-
first,
yeah.
okay.
It'd be recommending to the city
Same as
council.
above,
Okay.
yeah.
I'll make a motion to recommend zoning ordinance amendment, section 5.1 regarding accessory building appearance to the city council.
Support.
Motion, support, any further discussion? Seeing none, roll call, please.
Mr. Cusero,
Yes.
Mr. Nushai,
Yes.
Ms. Redmond,
Yes.
Mr. Sinaki,
Yes.
Mr. Solomon,
Yes.
Mr. Fitzer,
Yes.
Mr. Hara.
No.
Motion carries.
Thank you. Agenda item number 9 is a zoning ordinance discussion on the restaurant uses in the BRD 2.
All right, so at the last meeting, we talked about this. We had everybody here last time.
Yeah.
So everybody was part of that conversation. We talked about allowing restaurants in the BRD 2 district. Since then, it's become clear to us that National Coney Island actually has reopened on a limited basis. Like, they have some small hours now. So they're not 100% closed. However, there still is that franchisee for a national chain that's interested in that property. So that is an ongoing discussion. So the thing that originally sparked the conversation is still active. But in the course of the conversation, it became clear that there was quite a bit of consensus that restaurants should be allowed in the BRD2 district north of Anderson Court, that area that already has a mixed commercial, industrial, office, research character, and already has some restaurants. So the way I'm presenting it here, and you're free to disagree or agree with this, is that I put restaurants in there as a permitted use, and then if they have drive-through facilities, it becomes a special land use so that we can control how that interacts with, say, nearby residential properties or something like that. And if you want to move it all to special land uses, which is something we discussed last time, we could do that. But I wanted to present it this way and then see how you felt about that and go from there.
Why would you want to put them together?
Well, I mean, honestly, I don't think they need to be special land uses if they don't have a drive-through. I think the drive-through is kind of the disruptive, like cars idling, noise. You want to have some control over that, where it goes. But as far as just a normal restaurant, I don't really see why it would need to be a special land use. Most stuff is happening inside, and it's a restaurant. I mean,
I agree.
Like I said,
Yeah.
they're already there.
What changed our minds about the drive-through specifically was the actual property, right?
Right,
So
yeah.
it's more specific to the property and if it can actually traffic flow, the actual
Exactly.
lot lines, how far setback they actually have. So I like it. I agree.
Yeah, they have
Especially-
plenty of room to put a drive-through there. They're not abutting any residential properties, so there's no noise level problem with it. The only problem I see is traffic flow, and if you put a no left turn sign at their exit, so they're not trying to force themselves out there on, they're on Maple and Crooks, not 14 Mile and Crooks also.
Yeah.
It's still in the
Oh,
document.
yeah, I forgot to update that.
Yeah, if we just say, yeah, you must turn right as you exit.
Well, wouldn't that come up during the special, we're
Yeah,
not talking
that's
about
all.
this by site specifically, we're talking about the overall ordinance, right?
Yeah, you're talking about the overall ordinance, and what making the drive-through facilities a special land use does is it gives you the opportunity to do exactly what the chair was talking about.
Okay.
Which is say, all right, We have to think about how this site functions, and you can place reasonable conditions that are related to the health, safety, and welfare of the public on a special land use.
So can you imagine or describe a scenario where, what would you do to regulate the drive-through portion? So I see here that you're encouraging them to be a restaurant there, so, but if you want to build a drive-through in there, you got to do what I say. So what would that even entail?
Well, we have specific standards for drive-throughs, so they have to meet those to begin with, no matter how they're permitted.
Yeah.
But again, drive-through facilities have higher traffic, they have a lot of considerations around them that a typical restaurant does not have. And exactly what he was just talking about is the kind of thing that you can do with a special land use. You can say, you know what, it doesn't really work here because the site's not got the right characteristics. Or you can put those kinds of conditions on it that just give you a little bit more ability to exercise some control over it. And, you know, I could think his example of a no left turn sign is one of, you know, many that might arise.
Will they be in the position of having to come in here for a site plan on this building?
But yeah, if they put a drive-through on the site, absolutely.
That
'cause
would
they'd
be a
they'd
special use if we
heavily,
approve,
yeah, it'd be a
right?
special use, and they'd be heavily reconfiguring the site. So the
Right.
parking would be changing, the whole layout of the site would be changed. They'd have to come
So
here,
one of our
absolutely.
stipulations would be no left turn sign.
Yeah, exactly. It could
exiting
be,
the
yeah,
place.
exactly.
So, Joe, on this B, okay, no, sorry, C, essentially, I see your language here, and it says B3, but we would include BRD2 and B3 then, right? Or,
B3, where's this B3?
wait, maybe I'm looking at the wrong one, but, all right, drive-through, maybe I'm looking at the right. 28. Okay, so we're looking at the ordinance to
It's a memo
amend.
that says restaurants in the BRD2 district at the top.
It's very short.
Oh, okay.
It's only one page,
Okay,
yeah.
I was looking at the ordinance to amend
Oh, you were looking at
drive-through
the
standards
drive-through
in
standards
section 4
themselves,
point.
yeah.
Yeah, is that not, am I not?
That's not what we're talking about right now. That's,
Sorry.
yeah, we already did that one.
Okay, never mind.
I'm just,
Wrong one. Okay,
We'll catch that later, yeah.
okay.
I'm just trying to understand, like, I think if we don't want to drive through there, we should just say we don't want to drive through. And if we're
Oh,
okay with the
gotcha,
drive-through,
gotcha.
I don't understand
Yeah.
why we have this extra provision for special land use if we can, during the site plan approval, say you've got to have a left-hand turn sign or.
Because right now, it's not allowed in that area.
Yeah, I mean, drive-throughs aren't allowed there at all right now.
Restaurants
Restaurants
aren't.
aren't either.
Yeah.
And again, a drive-through is a different level of intensity, and I just think you want to have a little more control over it. Because one thing that a special land use gives you that a permitted use doesn't is it gives you more locational control. If someone were to come in and ask to put a drive-through in a location that, I don't know, let's say it was surrounded on two sides by residential uses, and you just felt that, you know what, it's in the district, but that's not the right location for it, it gives you that ability, that greater discretion than an actual straight site plan for a permitted use.
Yeah, I get all that. I think if it doesn't make sense for that site, we shouldn't do it. We should fail the site plan.
If I may,
Yeah.
I think you're getting confused because there's been so much talk about that specific site.
Right.
We're talking about the zoning district itself. So this changes for the whole district, not that site.
Right.
So
So it may be appropriate for that site, but not other sites necessarily.
there may be other sites within the district where you wouldn't want to drive through, therefore you would want the special land use to have that.
You nailed it. Thanks for clearing me up for me. You're absolutely right.
Any further discussion? Where do you want to leave it now?
You could set a hearing on it. That would be the next step.
A public hearing on it?
Yeah. And I'm just looking at the dates here. I'm assuming you guys don't want to have a meeting on the 27th?
Probably not.
So that would be too soon for a hearing anyway, but I was going to talk about it at the end of the meeting, but I think we're not going to have the meeting on the 27th. let's see, our next date after that would be the 10th of January. So you'd set a hearing for either the 10th or 24th of January. It would be at your discretion.
There's not a whole lot of discussion that needs, this is very short, right? Okay.
Yeah.
Can I, all right, I'll make a motion and you guys can shoot me down if you want. I'll make a motion to move zoning ordinance for public hearing on January 10th, restaurant uses in the BRD 2 district, sorry.
Support.
Yeah, motion, support, there's plenty enough time to get the announcement out for the
That is enough time, yeah.
public.
Yep.
Okay, do we need roll call for that? I guess so, right?
Yes.
Roll call, please.
Mr. Solomon,
Yes.
Mr. Fitzer,
Yes.
Mr. Hara,
Yes.
Mr. Kucera,
Yes.
Mr. Nushai, Ms. Redmond,
Yep, yes.
Mr. Sinaki.
Yes.
Motion carries.
Thank you. Agenda item number 10 is the master plan review.
Yeah, so what I've done this time is I've gone through the goals and objectives and the action items from the last plan, and I've offered some comments. Just to, as kind of a starting point for discussion, and just to kind of give us a sense of what we're dealing with in terms of where we are relative to the goals set by the last master plan. So, master plan goals can be very specific. They can also be very general. It really depends on what you're trying to accomplish with the individual goal, right? So goal 1, for instance, is attract new business and industry to the city. That's a broad statement. And then from there, it drills down into 4 objectives. So increase the marketing efforts of the city is 1. And then encourage entrepreneurial development and assistant programs, encourage the startup and relocation of emerging technology and high-tech industries, and promote the development or redevelopment of existing structures to reduce vacancy and blight is the other one. So we have differing levels of control over those things. 2 of them say encourage. They don't say, like, they don't necessarily send us in a particular direction. They're just talking about encouraging things. So outside the DDA, I think more could be done in terms of marketing efforts for the city. From the planning commission's perspective, most of your work toward achieving goals in the master plan is done with the zoning ordinance. So if you're enabling reuse, if you're permitting the right uses, if you're, say, permitting restaurants in a district where restaurants are logically permitted, like we just did, then you're working toward those goals, right? I think a broader look at the list of uses in the BRD 2, O1, and I1 districts is probably merited. Some of our other residential districts could probably use a look as well. Those lists, they're established at a certain time and they age just like everything else. So it's good to review them now from time to time. And then listing uses like co-working spaces and business incubators, that could help promote their establishment by making them unambiguously available. So kind of more innovative type uses that are becoming kind of common as a lot more people move toward entrepreneurship and, kind of low overhead operations where they may still want to have access to a facility for working or collaboration. Those types of spaces have become much more common in recent years. And, I don't see, for instance, why a maker space wouldn't necessarily fit in the BRD 2 district.
What space?
A maker space.
Oh, okay.
Where people can come and use an array of tools that are available, and you don't have to have your own, you know?
You're talking like Masterworks or whatever over?
Yeah, something like that.
Something
Yeah,
like that.
exactly. That kind
So
of
it's more
thing.
so than like a Bamboo kind of Detroit. I feel like that kind of is a little dated even, like the Office collab
sure,
stuff.
yeah, right,
You're talking
yeah.
more hands-on collab.
Yeah,
Okay.
exactly. But you could do both, you know?
Okay.
You can say both are permitted, you know?
Okay.
You know, obviously, the planning commission doesn't have much control over marketing efforts of the city because it's just not your job. But it's still something you can call for in a master plan.
Hey, Joe, so I'm sure when this came out, there was like the whole .com thing still happening, right? So that's probably why we call out, you know, the technology, high-tech industry. We're trying to be like, you know, California or something, I don't know. Everything I've read recently on what's growing in cities is medical. A lot of
Yeah.
medical industry. Is there an outdatedness to even identifying that industry specifically and not, and I don't even know what I mean by medical, like obviously not a doctor's office, but like laboratory, perfect for like I-1, you know?
Sure.
Is that something that we could possibly explore along with your other list?
I mean, I think you could expand your sense of what high-tech and technology is into the medical realm, absolutely.
Do you
And-
see that as something that's already kind of like fulfilled, or do you see that something that we might be able to open up and bring in more business with certain, you know, additions or takeaways?
There may be terminology or something that you could settle on that might make it a little more clear that you're looking for that kind of thing. But we'd have to look at the list of uses in some detail and kind of determine whether or not we want to add something.
Is that something we could maybe explore possibly more, or do I need to make a motion for that?
We can
On
just
that-
make a note of it.
Yeah,
and
on that
explore
note,
it.
Joe, can you kind of just specify, since master plan review in the agenda?
Right.
What are we trying to accomplish tonight? Like, just so we don't get too off track and I make sure, you know, we use our time wisely.
Sure,
Do you want us to
yeah.
go, are we going to try and tackle like certain goals today and then come up with recommendations? Or is this a
Well, I
general
think
review?
really what we want to ultimately describe, and I'm not going to go through all my comments like this. I'm just doing this one to kind of set the
No,
table
I appreciate
here.
that, yeah.
But yeah, I think really what we want to do is for each goal we want to say, you know, is this something that either we want to carry forward, we want to look at and reassess, or maybe I don't know, maybe there's something we would actually dump. But it's kind of like we're just determining for each of these goals, all right, do we want to carry this forward? Do we want to make it a focus of a potential master plan update?
And
and
I
do
guess
some
the
reassessment
reason I'm
there.
asking too is because I know when we last spoke, we talked about doing more of a workshop integrated session, you know, with other
Right.
groups and anybody who may have opinions and thoughts, right, besides just this body.
Right.
So I just wanted to make sure I understood kind of the steps for this overarching master plan
Right.
review and what today is.
Yeah, I'd like to get you as a planning commission who creates the master plan, I'd like to get your sense on these things before we go to that kind of environment, basically.
Got
Um, So, I mean, I think obviously attracting new business and industry to the city is probably something we would want to carry forward with. Are there any thoughts about whether or not that's something that we need to revisit extensively, or is that something that more or less carries forward like it's listed here?
I think it carries forward with potential tweaks.
Yeah, just small changes.
Well, and I'm wondering if there's any feedback that you might have from like DDA in terms of potential obstacles or potential things that we can do. Can we solicit you to kind of get feedback from the DDA in terms of, you know, what we might be able to do to change or welcome more opportunities there? Is that appropriate here to say, or no?
Certainly, the DDA has its own, marketing efforts and things, and programs, and there may be a way that, those could translate outside that district, or a version of them could maybe be applied more broadly through the city or something like that. So, yeah, I mean, certainly that's something that we could talk about.
Just in terms of industry in general, they have an idea, right? Or no?
I think the DDA maybe is a little less industry and more commercial. and-
Restaurante kind of thing?
Commercial and retail and,
Yeah.
But, you can always put in, you can always reference all the programs and initiatives that Oakland County has. They have ones targeted towards medical, they have others, so.
Right.
It's just giving people, sometimes it's just giving people where the resources are.
Through the master plan, you mean like go here for a grant, or is that what you're referring to, or?
I guess I'm thinking more not so much master plan, but on your website.
Oh, I'm totally with you there, yeah.
Giving people, just pointing, our website, has all of those things, so people can go down our resource page and find all of them.
Okay. You mean the DDA's website, right? Not the city's website? Okay.
I'm thinking that, based upon my 2 years in the Planning Commission, that the scenario ought to be along our major corridors and recognizing that, at least in the current atmosphere and technology, that we might have too much office space designation.
We definitely have too much office space.
And maybe not enough commercial, and maybe in some corridors that something similar to the, you got to refer to it, the old Maple Florist planned unit development, where there was, on the street front, there was a slight business application, but it was multifamily. And I would think that, given all these objectives that you see here, they all tie together. But I'm thinking that our master plan ought to start having a defined strategy that says that these areas maybe need to be rezoned for future use, and maybe in the process of that, we recognize that there might be a 80-year-old farmhouse on one of the major corridors that, if it's getting to the point where somebody says it's economical, that it's no longer residential, it ought to be directed towards, retail, commercial, or multifamily, or a planned unit development type of project where you have your, a small business, and then maybe multifamily or something like that. And I think the Planning Commission should be doing that and making recommendations, saying we've got this strategy, we've been educated by Oakland County and the state of Michigan and our planners, and says that, we really ought not to be encouraging, some of those traditional farmhouses that were there when it was really a farming community, and transitioning that over. And you've at least educated me a lot in the area along Rochester Road, in that major middle section of 14 Mile, where it's a big mismatch of a whole lot of things. And you look at our zoning ordinances, and it's kind of directed in a zoning to accept what's there and be zoned that way, but maybe not. And if you keep it that way, I'm thinking that in a master plan strategy, that's not what you want to have. Nobody really wants to put up a 3,000 square foot house in that major section of 14 Mile. But our zoning ordinances right now may or may not, be
Sure.
permitting that and encouraging it, as opposed to this transition scenario. So I see a lot of this stuff is, what is, if this is in our master plan, if this is what the city and the residents of the city wants us to do, then how does the planning commission start to put that into a documented strategy?
Sure, yeah, and I think, that goes pretty directly to goal number 2 on page 2 of that memo, where it talks about prioritize development and revitalization along the main corridors. That's one that I think really should be a focus here, because there was a call for creating a single district along West 14 Mile in the last master plan, and that's something that hasn't been done. But I completely agree with you that particularly at Main Street, there's all this office zoning. I mean, I don't really see a lot of offices being proposed up the Main Street corridor in the near future. There's just not that much demand for office right now. And we need something a little more flexible up there. And to revitalize the Rochester corridor, probably need to take a much closer look at it. In the last master plan, there wasn't really any focus on the Rochester corridor. So taking a look at it and really treating it like the important part of the city that it is, and trying to develop a vision for it in the future, is something we should be doing as part of, if we were to do a master plan update, it's something we should be doing.
Hey, Joe, can I ask a question on that? When I think of that, it's easy enough to say, okay, you can put something else here if you want. With that, we're going to have to consider parking. We'll need to consider
Of
height of
course.
buildings, because if we want to open up to like a mixed use, which I think might be very compatible in those areas, it's not going to make sense unless they're able to build up or out. There's not a lot of parking. So with that said, I think that's a little bit beyond our capacity to kind of know how integrated that might turn out.
Is it though?
Is it? Well, if we opened up
If we had
everything, if we opened up everything
if we had a
on red-
master plan update, then we
Okay,
would
but
have
I'm
a
hoping
budget to
that
study
with
it,
that,
you
is
know.
what I'm saying is, I'm hoping that with that, you'll give us detailed information about how much, if we opened up all of, let's see, BRD 2 to allow to go up 2 stories, and have, mixed use, what that parking might look like in the ramifications of that, what that might be in terms of.
Sure.
Oh, does that mean that residents are gonna have like awful parking? The city's gonna have awful parking downtown? We're gonna have to no longer be able to like have streets clear by, 2 a.m., whatever it is. There's a lot of, things that come along with doing that, which I'm totally on board with, but I would just like to know what that might look like fully.
Mm-hmm. Yeah, that's absolutely will be part of whatever study we were doing, yeah.
And are we doing the study, or are we out, like,
Well,
what do you mean in the study?
we're not there yet, because we're just looking at the master plan right now, and ultimately, we're going to make a recommendation to council to do a master plan update, or not do a master plan update, or, and if we are making a recommendation to do an update, we're going to say we should be focusing on these areas, and the corridors would be one of them.
So in our recommendation, would we say we would like to do a study on allowing for mixed use, and we'd have to call out, like, we need to know about parking and how high
You
the
wouldn't have
buildings?
to be that specific.
No?
You call out that you're going to look at the corridors, because we don't necessarily know what direction we're going to ultimately go in. We need to have some public forums and hear from people and kind of understand where the community's heading. And from there, we can develop, kind of a list of study priorities and study it and then come up with some recommendations. So we're kind of a long way from that level of specificity at this point. But you would identify the corridor, like the Rochester corridor, as a study area.
So just as okay, because, and I hate to keep going. Outside of office, some of those spaces, as they are, won't work for much other than an office, as they are. So without changing the actual footprint of those sites, it's going to be really hard to just say, oh, we'll just rubber stamp this as this and that. And then we're,
You have to think beyond individual sites when you're doing corridor planning, though. You really do have to understand that, you know, so if somebody were to do something transformational in one of those corridors, they might have to aggregate multiple sites.
oh, I'm sure they will, yeah.
And you can't worry about that so much. It's a realistic consideration, but it's a realistic consideration for whoever ultimately proposes to do something, right? That's part of their due diligence.
Okay.
And we have to think more in terms of the actual corridor as a whole as we're planning. And we can talk about, you know, practical considerations such as what actually fits on a site and how much parking might be needed for a mix of uses. We can talk about that stuff because they're limiting factors, right? In terms of what we can put in there. We can't put a bunch of 8-story buildings up Rochester Road
Well,
and
but
think
that's
it's a
part of it.
reasonable
Like, are we
plan,
just
you
going to
know?
say that, like, O1 is going to allow for, I guess maybe I'm going too far into the details here, but like,
Yes.
if we're, okay, I do it a lot, obviously.
I mean, not to be facetious or anything,
Right,
but yes, we really just aren't there yet in
Okay.
terms of the details.
Okay, so
yeah.
we'll talk about, not in terms of converting to a different district, defining it as its own district
Yeah,
then,
we're
right?
really, we're talking about studying a corridor. at this
Okay,
point.
gotcha.
So that's what we're doing. We're
Okay.
identifying corridors that we might study. And then, provided that ultimately we make a recommendation to that effect to council, and council says, yes, we do think it's time to do a master plan update, and we're going to give it this scope, and we're going to establish a budget for it. Then we get into the doing the study, and all those specifics come out later. But for right now, we're just saying, yes, it's clear that we need to do more work looking at these corridors. Some of the, you know, conclusions that we wound up with last time need to be revisited. And some of the corridors that weren't studied last time need to be studied. And, you know, we'll see where that takes us. But right now, we're just saying it needs to be done.
Excuse me, Mr. Chair.
Sure.
This is at least the 5th time I've had to listen to this conversation go around with very little traction made anywhere on it. So I'm going to put it this way. I get the idea, Joe, that you are unclear whether it's the ambition of this commission to pursue an update to the master plan or not. I think we should figure that out. And if we need to make a motion to do it, let's do it. As far as the scope of that update to the master plan, which we are, by the way, not entitled to take an extra 10 years to do. It is 5 years. The deadline is approaching, and we're about to exceed it. So one way or the other, I think we have to deliver something to council soon. The Michigan Planning Act is very clear on what our role is in the master plan. And it says that it should address land use, which is what you're all talking about, and infrastructure use issues, and may project 20 years or more into the future. Those are the two things we have to be concerning ourselves with: land use and infrastructure. Now, I have said at least 5 times that I'm frustrated with the complete lack of discussion on infrastructure, because to me, just as important as should this be a bank or an office or a hospital, great things that are largely not in our control, the best thing we can hope to aspire to do is make sure our ordinances and our zoning isn't in conflict with what the general trend of business wants to do. And if it is, we should fix it. And if it's general and universally accepted and encouraging businesses to come here, then we should leave it the way it is. I'm much more concerned about the infrastructure because I'm intimately aware of its decay. And I'm concerned that we have no ambition to even study it or make it part of a plan of improvement in the future. If you guys don't agree with that, that's fine.
That falls, I believe, under the heading of our capital improvement program, though.
Part of it
The
is.
specifics of it do,
repair-
yeah.
In order to repair infrastructure, we all know we have bad roads, we have bad plumbing, we have bad sewers. We all know that, but we don't have the money to repair it at this point in time. So that's, but that's the CIP, I believe, is to figure out where the monies that we can get and where they're allocated to.
Well-
It's obvious a master plan, yes, we want to fix the city, but financially, how do we go about doing that? That's the glitch.
I guess my response to that, Mr. Chair, is it is entirely possible that we are not able to craft the perfect infrastructure due to our financial abilities. But I don't think it's in conflict to say what you are stating, which is absolutely true. I don't think that's in conflict with us having an ambitious plan that says if we want to support in 20 years a town of thriving businesses, thriving schools, and thriving homes, that they need a functioning sewer to do so. And if we include a proposal that, or a plan, or even if all we do is raise awareness that this is the weakest part of the city that needs the most priority for CIP, or this is the most up-to-date, this should be the last place we pursue CIP, doesn't mean we're going to do everything, but at least it would be part of a plan. To quote a neighbor of mine, he said, "I don't need to know that my street and sewer is going to be replaced tomorrow. I just need to know it's part of some plan, and someday someone has already put it into priority." That is not true today.
No, I think it is, actually. DPW did put it in order. And I do agree with you on the point that it's not readily available to most people, but DPW they have set forth a plan. And I've only known that from watching city council meetings that they've gone in front of and said, this is what we plan to address this year, next year. Are you looking for more than that?
Such a document exists that describes the weaknesses of our city. That is
Yes.
true.
Yeah.
But it is not part of our master plan. And the master plan absolutely does, and the Michigan Planning Act provides specific language: sanitary sewers, water supply systems, flood prevention, drainage. All of these things could and should be part of the master plan if it's required to carry out our next 20 years.
Yeah.
And
Joe,
if it was a brand-new city, if I may, I'm sorry.
No, sorry, go
So
on.
if it's a brand-new city with brand-new plumbing and brand-new cities, and for the next 20 years, nobody can conceive of a reason why we would need to concern ourselves with our plumbing, then it would be a great thing to overlook. But in this situation, this city being what it is, I think it's a glaring omission. So again,
We could add it, but
Right, I was gonna say-
what the master plan is basically a wish list, a wish we have this, wish we have that. We could say we wish that in 5 years we could repave all the roads in Clausen. We could put it on the list, but our ability to achieve it's going to be nil.
and I
Would
don't
you
think
like a
that-
meeting to overlook those details in terms of like what's happening in what way in the timeline that DPW put forward to see like opportunities or?
No.
I think we
What
can
are you
make a
looking for?
motion to include this as another goal, right? Is that?
I want the goal on the
Okay.
plan.
And that's okay, because I
Right,
mean,
sure.
the goal should be inclusive of instruct, I support that. And we do
Sure.
need to understand what steps have been taken to understand the problem and what be addressed. So I think that's a fair goal
I think
to
it's a
help
good-
us get our
good
head
point.
around it
Yeah.
and make a plan if we need to try to support
We
more of
work that
that.
in there, Joe?
Yeah, absolutely. And there are a couple goals that speak to the transportation network and things. But so a few things about the Planning Enabling Act's infrastructure provisions. So in a city like Clausen that's built out, a lot of what you're going to be talking about is how do you incrementally change what we have? How do you maintain what we have? How do you make what we have more effective? I guess if you were being really bold, you could talk about, replacement and things like that. But, if you've got a newer developing community, if you're building out into the green fields, you're going to be establishing sewer districts and water districts. And you're saying, here's where we're going to have water lines in the future. We're kind of way past that in Clausen. So, yeah, it is going to be more about how we work with what we've got. And that could mean that, we're looking at the layout of a major road. We have a 4-lane road right now that would be more effective and safer with 2 travel lanes and a turn lane. That's something that we would do in a master plan. And, the repair and maintenance schedule, we can highlight areas of extreme need, I would say, but ultimately that does go down to what DPW's done with its prioritization and its, that feeds into the capital improvement plan and everything. But we can identify areas of major need, we
Can I
can.
ask a question? Is this about sewers or about roads or about both? Because
Maybe
like,
about both.
to a certain degree, the sewers are the sewers and like, we're a
Right.
combined sewer system and we share it with the Red Run, there's only so much Clausen can do
We
to.
only have so much authority there. It's
Right,
true.
like when it goes out and goes all the way down to Lake St. Clair, there's only so much we can do to stop water from coming back. Because it's not just Clausen, it's every community that's shares that same. So I'm just looking, I guess, more so for like,
I'm sorry, Mr. Chair. With respect to my request to include the topic of infrastructure in revisions to the master plan, I'm trying to get there, and again, it may be that we can't get there. And by the way, I am not overestimating or overlooking the significance of that endeavor. That is a significant endeavor. It is going to be a lot of work, a lot of thought in this room and hopefully workshops outside of it with the appropriate people at DPW, et cetera. It is a big task.
If I may, are you thinking more about reconstruction, maintenance, or because
I'm thinking about ultimately, to be quite far out vision, when we approve capital improvements and when they come to us for our input, right? I believe with the intention that we can say yes or no, this money would be in congruence with the master plan if we spend it, or it is antithetical to the ambitions of the master plan. If they spend one dime on a sewer at the moment, I don't have a comment on it because it's not part of our master plan. And I think that's wrong. I think we should say, yes, what you're intending to do with the money is in harmony with the master plan.
we don't approve budgets though, right?
No, we don't. But we are absolutely now, newly, I think, for the first time this year, reviewing capital improvement projects with that specific purpose. Is it in line with the master plan or isn't it? And it may be a moot point, it may be an obvious thing. Well, of course we're going to approve the fire trucks thing, or of course we're going to approve a new vacuum machine for DPW. I'm not going to get into these details. I'm at a high level just saying it should be part of the master plan, at least cursorily covered by it. And if it doesn't, and if we can't, and if there's all these other resources that don't add up, so be it. But
Well,
at least,
but the only thing is we're not in touch on the day-to-day basis of like the sewer main that broke. So
Nor do we
can
have
you
to
just
be.
put forth like exactly what you want to address maybe
I would like
prior
a
to-
goal. I would like a revision to the master plan, and I would like it to include a goal for the quality and improvement of our infrastructure to support a 20-year growth plan for Clausen. I would like to say that in 20 years, if you plan to have a business here, there's going to be a sewer to support that business 20 years from now. I'm not even sure I can say that honestly right now.
So you're saying sewer, not roads, just sewer?
No, infrastructure,
it'd have to be
water, sewer, roads.
Water, sewer, roads, okay.
I mean, there are other ways that a master plan can speak to infrastructure, and that's by talking about things we don't have, like, biophilic infrastructure that might reduce the burden on our sewer system. It's not addressed in our current master plan. It's not addressed anywhere, really, because it just hasn't been discussed. But it's something that we could look at, and it's something we could discuss, and it might help in the long run with the overall maintenance of our sewer system. So that's the kind of thing that we could talk about, absolutely, And I think sustainability in general needs to be a bigger part of any master plan we do in the future. And that's one aspect of it. And you could talk about your power infrastructure and things too, with a distributed grid and solar and all that stuff. But, I think that we don't really talk, our current master plan doesn't really talk about resiliency, and it doesn't really talk about sustainability. And infrastructure is a big part of resiliency, and sustainability plays right into the long-term maintenance of your infrastructure. So they all kind of tie up neatly in a little bow, and I think that those are both things that can easily be addressed in a new master plan. It'll be a lot of work, but it's worth doing, So Yeah, I understand what you're saying, and absolutely, yeah,
Yeah,
I think it would be a focus area.
I would support that if you want to add additional goal. So I'm happy to do that, you know, whether it's now or we refine it and come back to the next meeting with objectives underneath the goal. But I think it's critical to have, especially the resilience piece, you know.
And we're pretty much making it our Santa Claus list right now. We're going to put this on the list.
Right.
And
Then we'll have public,
not be heartbroken if we don't get the
Right.
prize.
at least we know it's a focus area.
Yeah, at least we asked.
Right, you're recommending that, yeah, so, I mean, I'm getting the general sense that we're not looking to just affirm our 5-year plan that we've already got and move on. We want to make a recommendation to council that
Yeah,
there
to-
be some sort of update. I'm getting that from everybody. So, you know, and it's basically now, it's a matter of figuring out what do we want to recommend? Well, we know we want to recommend that. And we know we want to fold in the sustainability element of it. We know we want a focus on corridors. Is there anything else that we feel
Yes.
from here that should be a focus area?
I loved all your talk about bikes and bike paths and
Yep.
making it more walkable. We've discussed prior, I don't remember when, but finishing sidewalks along Maple, and I believe even Crooks might have some areas that there's not completed sidewalks. Potentially just making the city itself within the city, Clawson City Park, possibly having bike path, actually going from the bathroom all the way through might be nice if you're riding a bike. I've thought that only for 11 years. So I'm all about that. Yeah.
Yeah, okay, I agree with you there, and I also, I mean, that's infrastructure.
Okay,
Like,
we'll
you
put
know,
that on your
sidewalks
goal.
and things are infrastructure, so, I mean, it all kind of speaks to
Yeah,
the
I
same
saw that
thing.
in goal 2. And then also, I think a big thing that we should address moving forward, one of the biggest things that's happening in Clawson right now is the schools right sizing. With that, we're gonna lose basketball court, and that's our only basketball
Sure.
court in Clawson. We're gonna lose soccer fields, we're gonna lose baseball fields, we're gonna lose valuable playscapes and valuable green space. And I think that should be addressed as well.
So two
Is that goal
things.
5?
Two things to that is, one, yes, this document has to be in dialogue with your recreation plan. So we
Yep.
have to understand what they're doing with their plan, and we have to make sure that we're, you know, dovetailing with it nicely. The other thing is the current master plan has a page on non-motorized transportation. It's very general, and it needs to be more. This community could do so much with it the way it's built. Things are close together, you have the infrastructure for it, really. You've got a grid. There's a nice bike path or bike route map in there and stuff, but more could be done. And
Now, can we call out specifically working, since the school thing is going to be happening for the next 3 or 4 years, is that something that we can specifically address when bringing this in front of council under one of our goals, possibly, if there's agreement upon it?
yeah, school sites and loss of public land. I mean, that's definitely something that I think needs to be a topic.
Possibly in our future. Sorry, I'm just going to get this out there. I don't know what's happening at Meyer parking lot. I meant to look it up, but with the Meyer, and I'm getting to a point here because I know that's Royal Oak. But also with that, there's the main dragway from Meyer is all the way down Elmwood because it's great. It goes all the way to
Oh,
Rochester.
sure, yeah.
And I'm
There's a
wondering
light,
if
yeah.
we see a potential uptick in traffic, uptick in speeding and things like that along that main street and as a cut through in what we might be able to do as a city, especially considering Shawm, to kind of slow that flow of traffic through.
Yep, that's another thing that we can look at. Your complete streets portion, your non-motorized plan can speak to that, and it's infrastructure too.
And streetscapes,
So,
I'd say.
you know, you
Yeah.
could look at choking down the width of that street in certain places at certain corners or something, or putting more stop signs through there. There's all kinds of things that you could do. And those are all things that we could study as part of a master plan.
I'm okay
update.
with speed bumps too. I'm just saying.
I think when you're studying the issue for a master plan, everything's on the table, and you come out with your recommendations at the end. So yeah, absolutely. Yeah, we can talk about that.
Joe, going along the lines of your thoughts of Mr. Hara, how about if we invite the DPW superintendent, his name escapes me right now.
Travis?
And maybe to solicit.
Trevor.
Trevor, yeah.
Trevor, to solicit his opinion about all this. Maybe we get a better, more general idea of where our infrastructure is going according to them, and maybe we can get some good ideas.
I think
because I
that-
agree, I
Sure.
agree with you completely, wholeheartedly, about the infrastructure that we have. We have an issue in this town, and infrastructure is the big one.
I think that would be a very productive subject for a study session. Yeah, if we were to be doing a master plan update, you'd want that to be one of your meetings, right? Or maybe two.
Maybe let's
In
invite them
response to
over.
In response,
Right.
Of course, many meetings like that, okay? All I'm trying to get done in this meeting is to get agreement to add it as a goal.
Well,
Yes, we
Yeah.
want to change the master plan, and
Yeah.
we want this goal to be added, and that's all we have to agree to today, and I will be so happy.
Yay.
But
You
thank
shall be happy. However, I don't think we need a
all
motion
agree.
for that, do we? It will be a goal of ours. Or do you need a motion?
I would like a document.
I don't think we need a motion. This is simply a master plan review. I think as long as Joe understands where we're coming from,
I mean,
I don't think we need to put
I
in a
guess I
motion
could go
for it.
kind of two ways on that. One is if you're comfortable with, at this point, okay, we know we're recommending an update.
Sure.
And I think we could formalize that by saying, yes, we are going to recommend an update. And then what I can do, based on the discussion we've had, is I can write up a correspondence from the Planning Commission to City Council saying, we are recommending a master plan update. We've undergone our 5-year review. And I will put in the things that I feel you all have told me are your priorities. And you can then read that communication and say, yes, you got it right. Those are our priorities. You missed this, maybe de-emphasize this. You know, you can tell me what your response is to it, but then you're reacting to a communication that ultimately would go from you to council. And that's where this was always headed. But that's kind of what I think. It's obvious we want to recommend an update. It's obvious that we have some things to focus on in that update. And I think I can take that and write the communication to council and give that to you at your next meeting, and you can respond to it and say, I don't feel you quite captured this, but the rest of it looks good, or whatever it is you're going to say.
If you feel a motion is necessary, you're more than welcome to make one, but at this point, I don't think it's really
If I may.
called for.
Can we hold, I agree with you, that should be a proper path, in my opinion. However, can we have one more meeting of discussions with the DPW about our infrastructure before we can make a more comprehensive recommendation to council?
Is a meeting with them something that needs to happen prior to an authorization to do a master plan update, or is that something that would happen as part of the master plan update? I guess that would be my question to you.
Sounds like a good question to you.
I see it as our recommendation that we know we want to make edits to this master plan. That is a topic, and then to help define the objectives under that main goal, we would need those types of workshop sessions, which, we bring in outside groups for.
Comes after the recommendation.
Right,
then.
it comes after the
Right.
recommendation
That's
is
how I
received
view
and
it.
and approved, yeah. And then, let's just say council says, okay, we've got your recommendation, but we're not going to authorize a master plan update at this time for reasons X, Y, and Z. We could still do something like that. We could still have some sort of, forum and make sure that happens, but we would just be doing it under just different auspices.
Have to after 5 years anyway?
Well, that's the thing. You have to review it every 5 years. You can take a bunch of different paths from there. Obviously, the path that the Planning Commission wants to take is an update.
Okay.
And then ultimately it is on council's, desk at that point, and they have to say, well, okay, here's what our general fund looks like. Yes, we can appropriate some funds for this, and we can authorize a master plan update. But yeah, so I think, a motion to affirm that we're going to recommend an update and then direct me to draft communication to council would be appropriate.
There you go, he asked for it.
Yes. Only thing I'm saying in response to that is, again, to your point, I want many conversations with DPW, and I don't think they necessarily have to happen in this forum. We have to abide by the Open Meeting Act, of course, but all I'm trying to do is get agreement that we are resolved to pursue a master plan update, and I'm not even sure we're really ready to talk about submitting the language to council for approval.
We're not submitting a language, though. He's just saying to just tell council, hey, we
Yeah.
want to do an update.
Well, that's the thing, is I'm just drafting communication to you that tries to capture what you want to do.
Hey, we see these issues, or these things that we'd like to update in our master plan. Can you approve us for it?
Okay.
Yeah.
I think
I don't know if
Rachel-
we're required to do that or not, but at the end of the day, we have to submit a master plan to them, and they have to approve it or reject it. That's on them, but I'm just trying to get a quality document.
No, Joe
on
right
this.
now needs us to either approve his language, like moving forward and asking them for their.
I also
ability.
gathered that we're not allowed to pursue this on any officiality until we cross some threshold, so I want to do that here, so I would like to
Yeah,
make.
well, ultimately, it's council has to say, yeah, we're going to
Approve it or not.
authorize
Yeah.
the completion, a new master plan. So
Authorize that we,
that's what we're doing.
Explore it.
We're telling them why we want to do it and why we think it's the right move for the city at this time, and then it goes to
If they
them.
give us an okay and a go-ahead, then at that point in time, we could schedule a workshop.
And start crafting the
Yeah,
objectives
then we
one after
start
the
working
other.
on the plan,
Calling
exactly.
for more information.
We're essentially asking for permission, right, if you will.
Right.
Yeah.
Okay.
And council, with that, they would probably, ask us for a scope of work and we'd get more detailed and things. But
Correct.
for right now, I just need to come up with something that gathers your thoughts and communicates them to council. And then you can then tell me, yes, you captured it.
so right now we're only, oh, sorry, go ahead.
This would include a scope of work and a budget request?
Well,
Because then now we just added another step. So we won't be able to start anything until we put a scope of work together.
But right now, aren't we only asking you to say, hey, we want to discuss the items? And say, you're going to come back to us with that drafted correspondence with city council and say, hey, this is why we want to update our master plan. And then we'll say, yes, Joe, now go
Yeah.
present it to council, and then you're going to bring it back to us, and then we can start kind of getting into the nitty gritty of things.
right. Yeah, I mean, I think it'll have a general scope of work in it because that's what we talked about tonight. And then if council agrees, there's going to have to be some work to figure out what the budget and full scope is. So I think it's going to be a kind of a multi-step process. And
So
it's
we'll have a
gonna-
general scope, but then we'll get into what you were saying, nitty-gritty of it.
Right,
Okay.
because then we would figure out, okay, we're going to need this many public meetings, et cetera.
It is our responsibility to prepare this document.
Absolutely.
So
Yes,
if we
yeah.
need to go ask for money, or if we need to go ask opinions from DPW, or if we have to do whatever we have to do these things.
Yeah.
Occasionally, we'll have to ask council's, approval, and occasionally we won't. But again, I'm trying not to get too far into the weeds here, it's getting late. Can I make a motion?
Yes.
To add, or to add to our meeting minutes, Nick, that we as a council, as a commission, are resolved to update our master plan to reflect infrastructure vision, pending the input from the rest of the commissioners and Department of Public Works.
Wait, are you making a motion to have Joe send this to take this
No,
as?
I'm only saying that we are resolved among this commission to amend the master plan with
Yeah.
this goal.
That makes sense.
Yeah.
Can you repeat that, please?
I would like to make a motion, Mr. Chair, to add to the meeting minutes that the Planning Commission is resolved to amend the current master plan to reflect an additional goal in consideration of the city's infrastructure. which is currently not there.
Can I get a support for that before we go further?
I'll support it for the sake of
For
conversation.
the sake of discussion.
Please.
I don't know that you have to throw infrastructure in there. I think it's a simple question that we're just asking Joe to go to the mayor and council and ask for their approval that we look into the master plan. We can then, if, with their approval, then we start adding our wish list on it.
Right,
That's my opinion.
I share that same concern, because if the motion is just to add that one goal,
They'll hold us to it.
then we're only doing that, and we're not talking about the rest of the master plan. We want to review the master plan and update it appropriately with that bullet point, certainly, but we want to be able to review the entire document, not just add the goal.
Right, yeah, exactly, yeah.
Review the document.
So infrastructure is a justification as one omitted item from the current master plan. So Joe can say, we are recommending
We're gonna look at the whole
updating the
thing.
master plan because we feel like we're omitting
Yeah.
this
So, okay.
infrastructure and plus a couple other things we talked about today.
So-
And I think that's,
The two things I was trying to say is, first of all, no discussion, no debate. We want to make an amendment to the master plan. We want to make a
Yes.
revision, excuse me, to
Amendment,
the master
amendment is
plan.
good, yeah.
Okay.
Maybe the word comprehensive is useful, because I don't want, to your point, to only focus on infrastructure. We want to talk about the bike paths, other things.
But don't we have to have a public hearing to amend the master plan? You want to amend the master plan
Well, we
right
gotta
now?
get- We got to
No,
get mayor
no,
and
no, no.
council's approval
I'm
first
still,
before we go.
but he just made a motion to amend the master plan.
He's resolving that the planning commission wishes to.
Well,
amend
actually, it's more specific
the
than
master
that. He's actually resolving to have the meeting minutes. That's the operative
Okay.
terminology.
Yeah, I did.
Reflect that. So based on that, that motion is perfectly fine to address that particular portion. You
Right.
can then, Joe is obviously taking notes. He's going to take all the concerns with respect to all the potential amendments, make that as comprehensive a document as possible. But for purposes of this motion, we're only directing Nick to include that portion of the conversation into the meeting minutes. That's true.
That he wants to, just to be specific, that he wants to amend the master plan. He wants it in the notes that he wants to amend,
Yes,
but it's not
based on this
amending it.
correct.
We're only voting
Right,
to
you
have it in the
can't
notes.
amend it without
Okay,
actually changing the
gotcha,
document and
okay.
having a public
Thank you,
hearing and all
thank
that
you.
stuff.
So, okay, you're right. I'm not trying to
I'm over?
change
Oh,
anything
okay.
here, okay?
Well, that's.
My observation to the commissioners is that at this moment, it is completely ambiguous whether this commission has the ambition to modify the master plan or to leave it unchanged for another 5 years. So
Wait, you said it's ambiguous?
it has been for the last 5 minutes.
No, it has not. Okay,
Have made
can we
no
vote?
changes. I don't even know what we would vote on.
Attacking different subjects, but I think we're all in agreement that we all, I think.
We've
wanna
all
look at
said
it.
vote.
So what is the
include
correct
infrastructure.
terminology to affect that, to affirm that we have that aspiration?
I would say that it might be that we move Joe to take the notes and items that we've discussed here to city council for approval to address the review and modification of our master plan, something in the realm of that. I don't know.
Well, I
Is that a
don't,
motion?
Well, his motion's still on the
I
floor,
have a
so.
Motion's on the
motion
floor.
and a second on the table now, so do we have to vote that down
Yeah.
and then change?
so can I restate it since?
He can
I've heard
restate it, yeah, if
so
the
it's
seconder
clear.
agrees.
Okay.
Does it need a vote down?
Yes.
I think in order to make it clean, I would recommend that you have the vote, vote that up or down so that we know, and then you can make the next.
Then move on to the second
So
one.
it can be a positive motion.
I agree.
Okay, I take a roll call in that
Well,
case.
could you restate what it was?
Can we, yeah, I've kind of lost track of what we thought the motion was.
So the motion that Mr. Harrow was making reflected a change to the master plan to include infrastructure and to have that reflected in the minutes. Did I gather that correctly, Mr. Harrow?
You did. That was just for the minutes. He spoke specifically for the to be
Okay.
reflected.
The original
say that.
motion that.
If I could,
that Mr. Nush-
since the question was directed to me, okay, is a foregone conclusion, I want this in the meeting minutes. It wasn't in the last meeting minutes, even though we talked extensively about it.
No.
So that was something that was on my mind. Regardless, it should be in the meeting minutes. We don't have to vote to have things on the meeting minutes. If we discuss it, it should be in the meeting minutes.
That was your
first of all.
direct motion, though. I
But
was-
you got it right. I wanted to resolve that the commissioners here agree to pursue modifications to the master plan and to at least add infrastructure considerations as a goal.
Well, it's going to be in the meeting minutes because we're going to vote on it.
Sure.
You got it.
But yeah, I don't care about the meeting minutes. I care about us going forward with this ambition.
We vote on the motion.
So,
If I may,
yeah.
the motion that you made was for the meeting minutes, to be reflected, your discussions for the infrastructure, and all our discussion for the
Yeah,
infrastructure.
I know what you're doing. And I want to restate it so that it's
Oh,
not
okay.
that.
Well, I'm sorry, go right ahead.
I
Wait, you're amending your motion now?
asked him to clarify it. He said it. You have interpreted it in a way that is completely antithetical to what I had wanted. Okay.
Rather than vote on it, can he withdraw?
Yes, please.
All right.
I think that'd make it a lot easier. Withdraw
Okay.
the motion you have and start out again, start over.
Very well. Mr. Chair, I'd like to make a motion for the Planning Commission to seek out modifications to the master plan and to include, among other things, a goal for infrastructure improvements through the next, into the future infrastructure updates.
I'm going to need support for that.
Did he officially, does he have to speak out that he withdraws his motion though first?
He did.
You did.
Oh, he did? Oh, okay.
Will someone second the motion that's on the floor now? Guess we have a problem with words here.
Could
Yeah.
I,
You
I
can
feel-
second it and then amend it.
I'm trying to understand this. You gave us the language you need to go forth to council to get approval for a full review of the master plan. Right? If I support that, are we discussing it, or if we shoot it down, can we make a new motion with your original language? 'Cause I think you already presented to us and we went around in a
But I
circle
think
for
you're
20
throwing in
minutes.
the terminology that you want to look at the infrastructure is throwing us all off, because
His
we don't want
notes-
to look at just that. We want to look at the overall
His
plan.
notes are inclusive of everything we talked about today. When you
Right.
present that language to us to then, I'm sorry, there is a next step. You're going to present the language you captured today.
Right.
So it'll
Right.
include infrastructure among bike paths and the corridors. And then we can review that. We can approve the language you have to then be sent to council for their approval for our full review, which will include workshop sessions and further discussion objectives. So I just, I think we got lost in the language and
Yes,
the number
we
of
did.
steps.
Yeah.
Right. I mean, really, all I need is just for the planning commission to resolve
Approval
that they would like to update the master plan, and they would like me to prepare a preliminary draft of a scope of work and communication for communication to the city council. And then next time you'll review that draft communication, and then
So
we
did his
move
motion
forward.
die? Because I'll make that motion right now. I'm happy to. Was that dead or?
Why did it
did
die?
not
'Cause
get
nobody
No
seconded it.
support, so the motion's dead.
and why was that again?
Because nobody seconded
No one
your
seconded.
No,
motion?
I get that. I get that. Why is that so?
I think because you're throwing the term infrastructure in there, it's throwing all of us off. I think it confuses them. All he needs is direction to go on to
Correct.
council. And then when it comes back to us, then we can review
it's-
any part of it we want.
It seems to me, though, that we are resolving to change something, but we aren't saying why or what we want to change.
Right, because we don't have to take all that to council yet. We just need permission to look at it. Yes. Okay, can I make a motion, please, to give Joe direction to take the items discussed tonight to the city council and ask, wait, now I'm confused. And to write
The
a,
planning commission is resolving that it would like to update the master
Yes.
plan and directing me to draft communication to council outlining the scope of what we want those updates to be. That draft will come back to you for review prior to going to city council. And that's it.
that's, yeah, as moved by Joe.
Great, now we have the city planner making his own motions.
That was beautiful.
Support.
Okay, have a motion and have support. Roll call, please.
Mr. Fitzer,
Yes.
Mr. Harrow,
Sure.
Mr. Cusero,
Yes.
Mr. Nushai,
Yes.
Ms. Redmond,
Yes.
Mr. Sinaki,
Yes.
Mr. Solomon.
Yes.
Motion carries.
Motion carries. Thank
Okay.
you.
So next time, you will have that draft communication to council
Right.
for your review, and we'll finesse it as needed.
At that point, if we want, we can set up a meeting with DPW and ask a lot of questions.
We'll have to approve and I meant to have a discussion in between my second and the roll call, but I didn't implement that. But just to give you a little bit reassurance, we'll be able to either approve or disapprove of whatever correspondence, I believe, that Joe brings back. So if your infrastructure in the items that we've discussed here tonight, we feel are lacking in that, just, that correspondence, we can always insert that then. Is that cool with you? Like,
I don't know why we need to have permission from the council to establish our goal, or, I just don't understand that. But we're done. Move on.
Because if council decides that they don't want to relook at the master plan, it wastes our time. Why are we looking at it then if they tell us?
and they have to, the scope of work, budget comes into that, I believe, so
Yeah.
that makes
My
sense.
interpretation of the Planning Act delegates this responsibility to us. We are supposed to do this homework and present it to them. It's not their pleasure for it to be how they want it to be. It is for someone separate than them to come up with the vision for the future of the city, and for them to approve it or deny it, certainly. But I get the idea that it's in reverse now, and that's fine. The diocese
It's
decided.
not in reverse. They just have to give us permission to do the legwork. If you
I would like you to tell me where the Planning Act says that.
You mean?
That I have to get their permission to set up a
Our
goal
planner
first.
just told us that.
I know,
So
then fine,
we don't
the action
believe-
item's you.
As a practical matter, the work can't be done without some sort of budgetary authorization. It's just not.
We can't prepare anything without their budgetary approval. So fine, that's for everyone's mystery why I'm talking like this. I am using this as the guide, and people are saying, we can't do that because we can't do that.
Who said we can't do anything? We just
You all
affirmed.
did.
No, we affirmed everything you wanted to do.
I didn't want to go to council first, but it's okay to go to council. I'm not against it. I'm just saying, if someone outside of this meeting could show me in the law where that is the sequence of events.
Okay,
it
well, how would
help
you
me.
feel how would you feel if we spent 6 meetings sourcing all this information and the council said no? I mean, it seems like a misuse of resources.
No, there's not. Yeah, thank you.
have a discussion, unfortunately, without a proper motion on the floor. So I think we're in the next item, whatever that next item may be.
Which is other business. I was looking on my old list, I think you gave this to me a long time ago, basic parliamentary information. I can't find it readily, but I think if you decide that you want to call a workshop, you bring it up, make a motion, we vote on it, and if we do a workshop, we do a workshop. So we're not under that much control of the council. If you want to do the workshop, we can do it, if you can get support from us to do it.
Sure.
But the time might be wasted if mayor and council do not prepare for that. We're going to give them something that they're not looking forward to. It's an option to think about, though. No, it's a workshop. Okay, now we're on to other business. Anybody have anything else for other business?
Mr. Chair, if I may, we had discussed the authority of the Planning Commission to issue temporary occupancy permits and how that
PCOs,
has
yep.
not been the case recently.
Excuse me if I may. We have adopted a policy, a TCO policy that's been in effect for more than a year. It wasn't in effect for that one case that was brought up before. That was one of the reasons that we did adopt a policy. We have a policy now that's working quite well, that a bond is required before any TCO is issued. So that is, we've used that a couple times now. And that works very effectively. So the bond The cost of the bond is based on the amount of work that remains before a TCO can be, before a certificate of occupancy could be issued. That bond amount is determined by the building official with input from other members on the development team, and then requested. That then is handled by the administration in the building department. And when the work is done, the bond is returned and a certificate of occupancy is issued.
On that matter, you sent us this list here of stuff, and TCOs are on the list. Three Cats Attorney has the O&M agreement for review. What-
Operations and maintenance agreement that has to be filed with the county. The attorneys are, there were, the Three Cats attorney had some questions about some of the verbiage. It was sent to Rennis, and that's, all of her engineering work is done, the plan's done. It is just getting that agreement to the county.
And do we now have a bond on Dee Dee's vintage?
That is a whole other matter. Nick is actually handling that one. That we can't, no, the bond policy was passed after that TCO was done.
Okay. I'm tempted to, I don't know, let's open up for discussion here. Like I said in the past, I was very disheartened when they took the temporary CFO away from us and gave it to the building department. My feeling is I would like to make a motion to see if we can bring it back to us.
I would
It's actually
support that
working.
motion.
It's actually
It's
working
not-
quite well, the policy that we have now. And you also mentioned at the last meeting, and I'm sorry I wasn't able to be here, about having the building official come here. The building official is a contract employee who does in building inspections and makes sure that properties are up to the building code. So he's not administration,
My
so he
question
wouldn't
was-
have a role.
My question was, who signs these temporary certificate of occupancy?
He actually signs it once I've prepared it, because it says in the ordinance that it's issued by the building official.
And he's an outside source. He's not a Clausen employee. He's a contractor.
Well, he is listed as a Clausen part-time employee.
Never met the man, which I find somewhat amazing.
He,
As a building,
why, I guess I don't understand why he would need to be here.
I guess I was spoiled when Elvis was here. Elvis would
Well,
attend
we had
all
a
of our
building
meetings.
official who was also the administrator.
Right.
That's not the case now.
Okay, and I understand that Reness will oppose me trying to get the CFO back here, but
Mr. Chair, it's not that I oppose you. It is, as if you recall, the reason why the temporary certificate of occupancy authority was taken away from this board is because there is no authority for this board to have such authority. Right? We can't find, if anybody here can find me, and I presume it is both Joe and I, if anybody can, and we're both coming from different area, looking at the same area from different trainings and agreeing on this, that there's no authority anywhere to give this board that authority. It was given to you in error, to the board, I should say. I'm not speaking to you personally, of course. It was given to the board in error whenever it was done by way of ordinance. It was taken because it was the appropriate step to be taken. Now, I don't quarrel with, I heard the discussion that occurred last time. I religiously watch your proceedings. I don't quarrel with the logic of your statements, and a quarrel with the logic of the reasoning and the reasoning behind why you would want the temporary certificate of occupancy authority. It makes sense to me, but the law is not logical. And to the extent that we seek to introduce logic where we have no such authority, I think we'd get into trouble. So I think any such motion would be void ab initio from the get-go, would have no legal authority. So that's why I'm addressing you beforehand as opposed to after the fact.
I'll look into it further, but
happy-
from my point of view, I think it's better to have 9 people's eyes on the thing than one
And
person.
I couldn't agree more, which is why I say I don't quarrel with your logic.
But
I don't quarrel with it.
Okay.
But if you
had
can
a
find
motion-
me the
point of
authority.
order. You had a motion request. I would like to discuss it further here. Is that possible? Can we entertain that? You specifically asked You would like to see it
I
brought
would,
back?
I would like to see it come back myself,
Yeah.
but you're giving reasons why it should not come back, so.
You seconded it, right?
I seconded it.
Oh,
and then
okay, so
we
it's
started
discussion
talking
then.
about
Is there a motion? What's the motion?
No, he did make a motion.
Motion would be to
Oh,
restore.
excuse me, I don't think there's a motion on the floor, though. What's the motion?
I commented, I didn't make it as a
Correct,
motion
and that's
form.
that was my understanding as well.
And for the sake of discussion, it might not get us anywhere, I'll make a motion that the authority to dispense a temporary certificate of occupancy comes back to the planning commission.
Second.
For purposes of discussion, Mr.
Excuse
Chair,
me.
Sure.
You'll excuse me, there's a motion that this body can, there's a million motions this body can make, just like anybody. There could be such a motion that says the first planner that walks in on a given Tuesday in front of us, we're going to tar them and feather them. And I presume, depending on what day Joe walks in here, you may have 5 votes to actually pass that motion. You may even have council pass it on a 3-1 or whatever basis that we may have it.
Could you
That
speak into the
motion-
microphone a little
Yes,
clearer?
that motion would be void ab initio nonetheless. And that is what I'm suggesting about this motion today, to all of you.
Do you want to explain what the term means?
Oh, void ab initio meaning from the beginning, at the onset. It's not a valid motion. You wouldn't be able to enforce it. You have no such authority. This is a board of limited authority, as you know, right? A specific limited authority. And there's nowhere that I can find that would tell us that you have the authority to deal with TCOs.
What,
If
I
anybody
may?
can find that authority, it would be great, but I don't, Joe?
I'm trying to get to
anything?
discussion here among the commissioners.
And now you can.
You're sure?
By permission, yes, sir.
Yes,
You give me your permission.
we have a motion and support.
So I might,
We're
I
discussing
might
now.
follow your line of logic, Rennis, in terms of the best way to go about giving responsibilities and delegating responsibilities would be giving it to someone that actually has the mechanism to support and to trigger repercussion, to trigger something that might happen with the C of O. I don't know if I'm understanding you correctly, but as a planning commission, we don't have the ability, the enforcement mechanism, to actually hold those accountable. So if I'm understanding correctly, the reason why they are at the building department is because they actually have the enforcement mechanism within the board, the building department, to actually follow through. So essentially, like, we can do whatever we want and look at all of the C of Os we want, but like, we don't have an enforcement mechanism from this board to do much about things. I might be misunderstanding, but I'm thinking that's what I'm interpreting. Is that correct? Okay, so,
If we granted someone a temporary for a period of 6 months, and at the end of 6 months, they're not doing anything, they're going to come back in here and talk to us, and we'd discuss it, and maybe we'd give them another 6 months, maybe not. Maybe we'd tell them, this has to be done. It's a matter of enforcing things. We don't have the power yet. We're not going to be the ones going out there locking their doors. That's administration's going to be doing that. I'm just saying that, from my perspective, I felt much more comfortable with more eyes on the, as is now, we approve site plans, for an example. Okay, you can go and do this to your building, but you have to do this, this, and this. We give them stipulations. As soon as they walk out that door, they go their merry way for as long as they want, unless it's enforced. That's where I'm having a problem. And see now, if you're not paying attention to these certificates being handed out, you're unaware of what's going on around town.
yeah. Okay, go ahead.
Mr. Chair,
Sure.
I think a couple of things are happening here simultaneously, and I think we need to separate them. So first of all, I fully support in that this critical function of government be brought back to the Planning Commission, and that more than one person makes this decision, specifically because temporary occupancy permits are kind of a bypass. They're a go-around that is a little bit of a vague road that should necessitate increased oversight, I think. And right now, that decision is being made in a vacuum. And I don't mean to to question your intentions or your abilities. I honestly think you could very well be doing a much better job than I would on these issues. But as it happens, I have no input or no oversight to it, no visibility to it whatsoever. And it seems to me, and I'm going to segue into the second point. So the first point was I absolutely support bringing it back to the Planning Commission. This is one of our functions. I understood from the city attorney that because in his review of the laws, there is no specific delegation of this authority to the Planning Commission, it is up for grabs. And it is, he went as to say, as if we tried to make it officially our responsibility, it would be null from the minute that that motion was granted. And that was very intimidational to us to not even pursue it. And yet, sometime a year ago, in this same vagueness of language that he is referring to in the law, it was entitled for them to make a policy themselves to do this internally. I don't understand how that happened, but my request would be, and Nick, if you could add this to the minutes, for the city attorney to present the specific language that was referenced in that recommendation.
Hold the thought for a minute. It's now 10 o'clock, so I would just, I would go with a voice vote that if we can extend the show for another 10, 15 minutes. Is everybody okay with that?
As long as we move on to roll call. I think we've had discussion, there's a motion on the floor. I'd like to move on.
Move on?
Yes.
But
Wait,
we're sitting
Can we
with
do
a
one at a
motion
time?
and support on the floor, correct?
There's an original motion on the floor.
Right.
There's a second motion, which is obviously improper at this point in time. It would have to be after this motion is voted on.
which motion are we doing to extend the meeting?
Extend the meeting.
Well, the motion to extend the meeting can't occur.
Yes,
Yeah,
okay.
that's why I just wanted to show
Yes.
hands on the extended meeting.
Yes.
Nobody has a
Yes.
problem. Nobody has a problem with that, okay.
But
Now
now
we're-
there's a motion on the floor, the original motion made by Mr. Becerra, seconded by Mr. Hera. That's the motion on the floor.
Okay. I respectfully want to listen to viewpoints and hear everybody on the commission. I just I don't understand where the hangup is. Giving the building department has given them, like Joan was saying, the mechanism of the bond. And those are things that we can't implement. So
I mean, the motion I made was to bring it back to us.
what enforcement
Now,
do we have,
now,
though?
if we vote on that and we say, yes, bring it back to us, that doesn't make it a law, right?
No, sir, it does not.
No, it doesn't. So he's telling me I don't have the power to make my motion.
Well, you can make
You
it.
Make the motion, of course you can, all day. You just did. But I'm saying that the vote, if this body were to vote, you nonetheless don't have the authority. Much like you don't have the authority, again, to tar and feather Joe when he walks in on any given Tuesday, if you have such a motion that was passed by the body on a majority vote.
So how would
Nobody
we,
would enforce it.
how would we go about then?
You wouldn't, sir, you don't have the authority.
He's telling us we can't.
You don't. I would like to behave as if I run this country like the Field Marshal of the United States.
No doubt.
But I don't have the authority, which is why I don't. We operate within the authority we're given. This is a body of limited authority, unfortunately, and that's not part of the authority.
And yet
Can I just
somehow
ask what we're
it
missing,
is
what you feel like you're
yours.
missing from having, because I don't remember a lot of C of Os, or temporary C of Os prior to a year ago. Is there something that you feel like we're missing here on the planning?
The entirety of their review.
They walk out of here, and after 6 months, if they didn't do what they were supposed to do, somebody extends them for another 6 months.
Yeah, but like what happened before a year ago?
They would come in front of us and give us a good reason why they're not doing it.
Don't you think that the building official is better to talk to on that? Or,
There's a case on the table right now where it didn't go well.
Yeah, it's
but now they also are implementing bonds. I'm wondering what we're missing that, and we might be able to implement something that might fulfill that need that you feel like we're missing.
And the city doesn't want to discourage business by any means. And if you come to town and you're setting your business up, you're not quite ready to open the doors, you come in and you ask us for a temporary. And temporary means that, yes, we'll give you 6 months, get your stuff in order, and then come back and show us that you have, and everything's fine, everything's wonderful. But if they don't do that, they better come in here with a good reason. why they're not doing it.
And you're saying for buildings that they're not making any changes to the actual exterior, interior parking or signs or anything, but like just to occupy a building, am I understanding?
Rules are rules in my book.
No, I'm not trying to be
Yeah.
combative. Those are the scenarios for a temporary CFO, right? It's just
Right.
to like occupy okay.
So I guess I could withdraw my motion if I'm being told that it, cannot possibly succeed. I'd do some more research on it myself, though. I'd look into what other cities are doing, how this is being handled. It's always been a sore in my side. I've been very uncomfortable with that.
And if I were to be able to find, you can do whatever you please with your motion, obviously. If I were to be able to find such authority, frankly, pardon me, it may sound as if I'm invested in this particular outcome. I'm not. It doesn't matter to me. because,
Would you
again, I
mind
don't-
coming to the podium?
Well, I'll speak to this if you don't mind.
I do mind.
Okay, that's
Well,
okay.
that's
You're-
Speak to it, speak in front of the camera, and speak into the microphone where this is being recorded, because nobody at home can hear you when you make these statements.
Thank you.
No, thank you. Come up there and talk
Mr.
to
Chair,
people.
Point of order, please.
Excuse me.
Easy,
I am.
Easy.
They're being incredibly
You
inappropriate.
are hard to hear. I don't know if that microphone's working or not.
Thank you. I hope it is. Mr. Chair.
Now I can hear you.
Thank you. Mr. Chair, I'm not invested in this particular motion in any way, shape, or form, other than I want this body to operate under its proper legal authority.
Right, that's your
Nothing
job.
more. Exactly. And to the extent that if I were to be able to find such authority for this body to have it, with the body's, and the body's desire as a whole is to have such authority, of course, it goes without saying. And I think you and I, well, in the sense that this body and I had the exact same conversation, with the same exact spirited conversation occurring whenever we talked about it last time. I think there was no less a feeling of wishing for this authority to remain with this
Right.
body at that time. But the body then made a decision. There was a vote. There was a decision to send this authority back to the proper place, as we understand it, as I understand it, as Joe understands it, which is with the building official, which has the ability to issue, to place bonds in place, to require a bond in this matter, which has the professional training and expertise to be able to make these determinations, and which would, basically, even though it's one person as opposed to 9, nonetheless has the same exact authority as this body exercised previously, erroneously as it may have been.
I'm not trying to take more control. Well, in a way I am, but because I think that from my opinion, I think it was handled wonderfully over the years, and I've been very dissatisfied since it was taken away from us. So that's just my opinion. And if you're telling me that it's a legal matter, and I've heard that before, I'll do more research on this myself. I will look into it.
As will I, and I will come back.
At this point in time, I will retract my motion.
Thank you.
Just-
And I will do the same. I'll do the same.
Show me
I'll
some
go-
legal examples of, yeah.
I will do the same. I will, and if I'm able to find anything that offers any direction, if nothing else, I will bring back, obviously, to this body whatever I find.
Right.
And then you can make whatever determination based on the whatever I find.
Thank you, I appreciate that.
Of course.
Yeah. Okay, anything else under other business? Seeing none, we'll move on to the planners' reports.
Nothing tonight.
Nothing on the planners' reports. Staff report and training opportunities.
I think it's in the report.
It was in the packet, our last page is covering training opportunities. I think we've all seen that. And we'll move on to 14, legal update.
Mr. Chair, I also wanted to, first of all, this is a very spirited.
You might move to this mic. That mic is not working right.
If it's not, it's not.
I'm not quite sure this is.
Mr. Chair, I wanted to, based on the discussion from earlier, I took a couple of notes. One of them that I think remains relevant, which is with respect to vacant buildings, that's our chapter 44. We have, when I look at it, as I was looking at it just a moment ago, it is not the most comprehensive ordinance. Based on some of the issues that we have in our city, I wish for it to be more comprehensive. It doesn't come through this body, operates a little differently. Obviously, it'll go through council, but I think that requires some additional work. But that's where, that's where the vacant buildings come into play. And the only thing that I wanted, I know this has been a late meeting, the only thing I wanted to remind all of you, we have this ethics ordinance on our books that our city passed some time ago. As a part of it, it requires all of us, whether administration, city council members, or members of the boards, to fill up conflict of interest forms every year. I know that sometimes we forget, and I know that perhaps a couple of you may not have done so, or if you're new, if you haven't, please remember to do so. If you need a copy of it, just email me. I'm happy to respond back to you. Or August, of course, our city clerk always retains a copy. It's just a quick form, just a quick update. Would really appreciate it. Thank you very much.
Thank you. Before we go to adjournment, I'd like to thank Mr. Sinaki here. For all of his years, he's going to be leaving us. You're leaving the city of Clawson, correct?
I'll be retiring from General Motors in March, and we have a second home in northern Michigan, which is going to become our primary home. I will still, for a short period of time, have two residents, but I'm intending on moving my legal residence to northern Michigan. So with that, I believe that I've learned a lot. I hope that I've contributed a lot to the city of Clawson. And for the most part, it's been very enjoyable, even though sometimes it's a lot of work.
I just want to thank you before the meeting ends, because I officially on the record, yes, I think you've brought a lot to both the Zoning Board of Appeals and the Planning Commission.
Thank you very much.
Yes. I thank you a lot. I'm sure that the mayor and council will at some point approach you with that. With that said, I would entertain a motion to adjourn.
I'll make a motion to adjourn.
Support.
Motion support. Roll call, please.
Mr. Cusero? Mr. Nushai?
Yes.
Ms. Redmond?
Yes.
Mr. Sinaki?
Yes.
Mr. Solomon?
Yes.
Mr. Fitzer?
Yes.
Mr. Harrow?
Yes.
Meeting's adjourned.
Thank you, everyone.